I beg to mention item number 10, madam.
Yes.
Can it be taken up on the next week?
Item number 10, second week of November. Heard Mr.
All.
Paul Oscar, learned counsel for the appellant who seeks an adjournment on the ground of personal difficulty. The prayer is allowed. Let this matter be listed in the second week of November on a date to be fixed. by the
Yes. Obliged.
I beg to mention item number 2 on behalf of DK Gogoi Malad. He has some personal difficulty and accordingly he could not come to the court, Malad. Therefore, Malad, kindly pass over the matter for the day. Malad, can it be taken up on Monday, Malad?
Heard Mr.
M. Saike, Malad.
M. Sakyal, learned counsel for the petitioner who prays for an adjournment on the ground of personal difficulty of the conducting counsel, Mr. B.K. Gogoi. The prayer is allowed. Let this matter be listed on Mondays,
Third.
3rd November.
Obliged.
Maybe. I beg to mention for listing a MSc appeal matter. I am the respondent. Insurance, they have filed appeal matter.
No, one senior court is there.
Matter.
You have to mention before court of, a senior court is there.
Civil works one. Eight. Noblest.
May it please, my lord, I beg to mention item 11. It may be listed next week because my senior counsel for personal difficulties cannot attend today.
Second week of November. Heard Miss A. Royal, learned counsel for the appellant who prays for an adjournment on the ground of personal difficulty of the conducting counsel.
Fixed.
Let this matter be listed. The prayer is allowed. Let this matter be listed in the next week on a date to be fixed by registry.
But prayer for listing of a CRB IO matter. Actually, my lord,
Senior court is there.
so, my lord, what happened actually, my lord? It was last listed on 27th, my lord. That day, my lord, when the matter was taken up, and I was on legs, my lord. Actually, my lord, the office note, I had stick with the record. Office note was wrongly prepared, my lord. Though the office note mentions that service is incomplete, we had taken dusty and also had filed our affidavit. my lord.
Affidavit.
Yes, service is completed. So eventually it will go for admission. So let it come for orders, my lord. I will clarify these things.
Okay. You give a mention memo.
So I will submit a mention.
When?
But Monday
Tuesday.
is orders,
Tuesday in orders column.
highly. So case closed notice. Item number 1.
But what is to be done? What is the issue?
Let us.
Pending investigation.
No, charge sheet method.
So,
Yes.
Angus counsel is on leave, lordship.
What is your name?
S.
S.
Soot. S.
Heard Miss S. Soot, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. As this matter involves offense under POXO Act, let the notice be issued to respondent number 2 in pursuant to the prevailing notification of the registry in this regard. The petitioner shall take steps for issuance of notice within 3 days from the date of this order, returnable on when?
7.
I'll leave it to.
When?
It's 10 days will be equally.
Yes. Returnable on 11th of November. Let also the scanned copy of the records of the trial court along with the connected case diary, scanned copy of the connected case diary be called for. Registry to take steps for requisitioning the scanned copy. List accordingly.
May it please your lordship. Here in this case, lordship, the petitioners before your lordship is husband and wife, lordship. I have filed this application mainly on the ground that 48 notice under section 48 was not communicated to the relatives, lordship. That ground, lordship, that I have taken at paragraph 9 of page 6, lordship, that the relatives have never received a copy of notice under section 48 BNSS, lordship. Now, if your lordship takes comes to page 42, this is the notice. Page
The records
42.
have arrived.
Records are there.
Okay, okay. Page number,
42. This is the notice under section 48 BNSS, lordship. Issued to petitioner number 1. And relevant part, your lordship will find page 43 down below.
yes.
That type line, last line, lordship. Signature of the relative WT message. And note, your lordship will see the relative of accused person is informed, intimated and communicated about the arrest by WT message through their jurisdictional police station and also informed over telephone. Now from here lordship will find about the arrest. So whether grounds of arrest were communicated or not, that is not there. And so far my knowledge is there, lordship, subject to correction, that WT message are not, lordship, like facts. They typed it separately. Just I have got a format of that, lordship, WT message. My learned friend is also having experience on that, lordship.
No, but
WT
what
message.
happened in this case?
The-
This is a different case.
Different case, but I'm just showing the format of the WT message. So what they have placed, lordship, it is the type copy for the police. So what they have sent, that is not placed before the court. I'm on that, lordship. Because WT message is different. That is typed in short and in different manner. Because here also your lordship will find that in the note it is mentioned that informed communicated about the arrest. But whether grounds of arrest were communicated or not, that is not there in the notice. As per Bihan Kumar's case, lordship, that grounds of arrest has to be communicated to the relatives also. So that part I'm placing, lordship. And whether the exact WT message was placed before the court or not, that your lordship.
This is the only ground.
Yes, on 48, I am only on 48.
Yes,
Uh,
whether.
Lordship, I placed on record, lordship. The day he was produced, lordship, they were produced, that is order dated 25/5/25. I have put a small tick, lordship. On behalf, the accused person has stated that they and their family members, relatives have been properly informed by police regarding the grounds of arrest.
Yes,
Whether that remand order will serve the purpose or not, because lordship, that is like questioning the court below, lordship, in my respectful submission. About the arrest on grounds of arrest.
there is a judgment of recent.
Lordship,
uh,
that I am placing.
After Bihan Kumar and
That's after darshan.
after darshan, where it is observed by the apex court that the explanation given by the court
Will not
before
serve the purpose,
will
lordship.
not serve
Yes,
the
yes,
purpose. Yusuf Nakinam,
Mohammed
Mansoor, Ahmed
Mansoor.
Mansoor.
Ahmed Mansoor and another. That is. And as per Bihan Kumar's case, if someone raised the plea that he was not served with the copy of the notice, then it is burden on the prosecution to prove that it was served.
No, but what has observed in Ahmed Mansoor's case?
That your lordship will see.
The last para.
Last, suffice it is to state that the explanation by the court before whom the arrested are produced can never be an adequate compliance of furnishing the grounds of arrest at the time of securing.
What is meant by explanation by court?
But by the court that if the grounds are read over to the accused, then also it will not serve. A copy has to be given to the accused person and his relatives.
No, but in this case, that is, in this case, the accused himself has admitted that he has been informed about the,
Yes, that may be because Lordship, when the copy was served, it was informed that W2 message was sent, it was probably informed to him.
you find
So
out,
whether the W2 message was communicated to the relatives or not, that is the relevant part.
yes, yes.
They may send a copy.
You find out whether WT message was,
WT message is there, Lordship, in the record.
it is there.
WT, but Lordship, my experience commission is Lordship, when the accused himself has stated to that effect, free from any portion or anything, Lordship, he has himself stated, Lordship, that the grounds of arrest has been communicated to him as well as the family members, Lordship. And this is not a statement, Lordship, which the court has put by itself, Lordship. On being asked, Lordship, they have stated. So they-
Whether it was in writing or not, that is it.
Grounds of arrest have been communicated, Lordship, that has been stated.
The requirement is that it has to be communicated in writing.
If he is in custody, how he will know his relatives has received the copy or not? He will not know, Lordship. He was in custody of the police.
Where is the WT message? Whether this. You see, go through it. Have you gone through it?
No.
Mr. Sharma,
Lordship,
then go through the Ahmed Mansoor's.
I've done so, Lordship. There, Lordship.
Into the auction.
There is no
Yeah.
grounds of arrest in the WWT. In Lordship,
last
the
time.
observation at page 5 also, I have.
Yes, what it means.
Lordship, if Lordship takes the paragraph 5.
Page 5.
Page 5 also, Lordship. The observation at Bihan Kumar, state of Haryana, Lordship, this paragraph also, Lordship, states, Lordship, that the object has to be fulfilled in short, Lordship, the object has to be fulfilled. Then, Lordship, the observation goes on to says, Lordship,
Okay, your submission is that,
Lordship,
that as the court before whom he was
Yes.
produced
yes,
has made an observation
Yes.
regarding compliance of 48
based on the Lordship,
material before the court.
yes.
But
based-
that material is before us also.
Yes, based on the statement of the accused himself, Lordship, that he himself has stated that the grounds have been communicated to him and his family properly, Lordship. So that observation, Lordship, on being asked, the accused person have stated. that
Okay,
they-
suppose, let me give you a situation.
Sure.
The IO at the time of arrest
Lordship,
has orally informed the grounds,
Look.
orally informed.
Lordship,
He has not given it in writing. And when the question, the accused was asked question by the magistrate before whom he was produced, he stated that he was orally informed.
Lordship.
Then is it a compliance of section 48?
In this situation, Lordship, yes, probably, Lordship, if he has been adequately represented.
So in writing, it is not necessary
In
under,
that situation. Lordship.
under such
Yes,
circumstances.
because Lordship, he has to be adequately represented, no prejudice has to be caused to him, all that aspect has to be seen. Ultimately, Lordship, the effect of the 22 Lordship has to be seen, Lordship. He was adequately represented and he himself has stated, Lordship, in this situation.
So your submission is that substantial compliance.
Yes, Lordship, in my respective comment.
That
Yes.
substantial compliance already, Lordship, negated by that Ahmed Mansoor's judgment, Lordship, that substantial compliance will not. Be. That-
Where?
Okay. That last part,
Heard.
and one more aspect, Lordship, that,
We have to show, you have to show.
Just a small Lordship, in that judgment, which the Lordship has stated, there Lordship, the arrest memo was given, Lordship. There was no grounds of arrest, Lordship. In that case, Lordship, in this case, Lordship, Ahmed Mansoor.
Yes.
We have perused the arrest memo and find that the same nowhere conveys the grounds on which the accused was being arrested.
But in the instant case also, the WT message does not contain the grounds. Your
Yeah.
WT message, in WT message, basic facts are not stated.
Lordship,
Your submission is that
Lordship, there is a-
accused has admitted that he has been informed.
Yes, now Lordship, in this situation, Lordship, it did not have the grounds of arrest and he also did not state that they were communicated properly.
So your submission is that though grounds of arrest was not communicated in writing as in the form as required by law, but as the accused himself admitted that he has been communicated, therefore there is substantial complaint.
Here, Lordship, yes, that is the submission, Lordship, and he was adequately represented, no bias was there. Lordship.
Okay. Heard.
now, Lordship may kindly see that, Ahmed Mansoor judgment, that issue, paragraph 2. First paragraph 2.
Yes.
The only issue for consideration in this appeal is as to whether the appellants have been furnished with the grounds of arrest when they were apprehended. And if not, whether an explanation given by the jurisdictional court at the time of remand, followed by the remand order which indicates that grounds of arrest were explained, would be in sufficient compliance of section 43B of the UAPA. Then Lordship, that Kabir Purgasto judgment was referred, page 3, last paragraph, Lordship. The aforesaid position has been reiterated in Kabir Purgasto. We are of the firm opinion that once
But the
this court-
facts are slightly different in both cases.
Yes, but Lordship may kindly say the the jurisdictional court has observed that the grounds of arrest were communicated. But if communicated, when I raised the issue that I have, my relatives had not received the copy of the grounds of arrest, it is the burden of the prosecution to prove the same as per Bihan Kumar's case. And now what they have produced, Lordship, that WT message. Whether WT message contains the grounds of arrest or not, that your Lordship will see. Because Lordship, the Bihan Kumar's case, Lordship, last, if I may hand over the copy, Lordship. The added judgment of Honorable Justice Koteshwar Singh's part, Lordship, last 5 paragraph, last 5 line, Lordship.
Yes.
After that, Lordship, that Article 21 of the Constitution, hence, Lordship,
Yes.
hence, the requirement of communicating the grounds of arrest in writing is not only to the arrested person, but also to friends, relatives, or such other person as may be discovered or nominated by the arrested person, so as to make the mandate of Article 22(1) of the Constitution meaningful and effective, following which such arrest may be rendered illegal. So in writing, that was never done. And Lordship, through WT message, even in fact, the Honorable Apex Court is considering that aspect, Lordship, whether that service of notice through electronic mode is, Lordship, is a valid under the BNSS or not. that Satyendra Kumar, until judgment, his lordship is aware that various provisions of BNSS are considering by the Honorable Apex Court. And on two occasions, lordship, the Honorable Apex Court observed regarding that electronic mode. Just I'm placing that two judgments, lordship.
No, WT message is not electronic mode. It
No,
is,
But I'm
message is sent through electronic mode, but it is conveyed in printed form.
what I am on is lordship that they have send it through electronic mode by changing the format of the 498A for the 48 notice, lordship. They have not sent the entire 48 BNSS notice, lordship, to the relatives. They have made a concise, lordship, of the notice, and then it was sent to the relatives. So now whether that WT message contains the grounds of arrest or not, that your lordship will see.
Okay, heard Mr. A. Ahmed, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 483 of BNSS 2023 has been filed by the petitioners Shahrukh Ali alias Sarukh Ali and Mahmouda alias Mohaba, who are detained behind the bars since both are arrested on the same date, since 25/5/2025, in connection with NDPS case number 70/2025, arising out of Silchar PS case number 551/2025 under section 21C/25/29 of the NDPS Act 1985. The gist of accusation in this case is that on 25/5/2025, one Debobroto Das, SI of police, had lodged an FIR before the officer in charge of Silchar police station, inter alia, alleging that on receipt of an information through reliable sources regarding transportation of suspected contraband inside a grey color Maruti car bearing registration number AS26A2522 coming from Mizoram side, a search team was constituted and a Naka checking was organized at a strategic location. During Naka checking, the aforesaid car was intercepted and during search operation, 3 persons, including 2 females, were found in the said car. The present petitioners were also amongst the occupant of the said car. During search operation, 14 numbers of soap cases were recovered from the said car containing suspected, what was the containing suspected heroin. On weighing of the seized contraband, the weight of the same was found to be how much?
1239 grams.
Found to be 1239 grams stuff. Charge sheet has been laid.
Charge sheet submitted.
After completion of the investigation, charge sheet has been laid against the present petitioner
Page 26.
under section 21C/25/29 of the NDPS Act 1985. Learned counsel for the petitioner has submitted that both the petitioners have approached this court by filing the instant bail application mainly on the ground of violation of their fundamental rights guaranteed to the petitioner under Article 22(1) of the Constitution of India, as well as the statutory right under Section 48 of the BNSS 2023. Learned counsel for the petitioner submits that after the arrest of the present petitioners, though they were served with notice under Section 47 of the BNSS, and reportedly the notice under Section 48 of BNSS were sent to the relative of the petitioners through WT message. However, there is nothing on record to indicate that said notice were in fact served on the relatives of the petitioners. He further submits that in the said WT message, grounds of arrest were not stated as required by the law, and it only conveyed the information relating to arrest of the petitioners in connection with Silchar PS case number 551/2025. Learned counsel for the petitioner submits that communication of grounds of arrest in writing to the relatives/friends/nominated person of the arrested accused persons is also a constitutional mandate under under Article 21 of the Constitution of India, as observed by the Apex Court in the case of Vihan Kumar versus State of Haryana, reported in 2025 SCC Online AC 269. He submits that if the said mandate is violated, it would result in vitiation of the arrest itself, which would entitle the petitioners to get bail on that count. In support of his submissions, the learned counsel for the petitioner has also cited ruling of the Apex Court in the case of Ahmad Mansoor and others versus State, represented by Assistant Commissioner of Police and other, within bracket criminal appeal number 4505/2025, bracket close. He submits that as the laid down law regarding communication of grounds of arrest to the relative of the petitioners, which is mandatory in nature, was not followed in this case. The arrests of the petitioner have become illegal, and on that count they are entitled to get paid. On the other hand, learned additional public prosecutor has vehemently opposed the grant of bail to the petitioners on the ground that the quantity of contraband seized in this case is of commercial quantity and therefore embargo of section 37 is applicable to this case. He further submits that though in the WT message, comma, a copy of which is available in the case record, comma, the relatives were intimated about the arrest of the petitioners in connection with Silchar PS case number 551/2025, comma, however, when the petitioners were presented before the Court of Learned Chief Judicial Magistrate Kachar Silchar after their arrest, comma, and when they were asked by the learned CJM Kachar as to whether they have been informed about grounds of arrest, they answered in affirmative, and same has been reflected in the order dated 25/5/2025 by the 25/5/2025 passed in Silchar PS case number 551/2025 by the Court of Learned Chief Judicial Magistrates, Silchar. Learned Counsel for the Learned Additional Public Prosecutor submits that as it is apparent from the aforesaid order of Learned Chief Judicial Magistrate Kachar that the accused persons as well as their family members/relative have been properly informed by the police regarding the grounds of arrest. There is no violation of requirement of section 48 of the BNSS in this case. He submits that the accused persons have also engaged counsel of their own choice, and therefore the purpose for which the necessity of communicating grounds of arrest is there has been fulfilled, and there has been substantial compliance of the statutory as well as constitutional mandate.
Submission, Lordship, the present case, Lordship, Ahmed Mansoor, if Lordship kindly takes up the second paragraph, Lordship, the issue involved here is, Lordship, the non-compliance of 43B of UAPA. That equates to, Lordship, maybe, Lordship, 47. If Lordship kindly says, the only issue for consideration in this appeal is as to whether the appellants have been furnished with the grounds of arrest when they were apprehended. And if not, whether an explanation given by the jurisdictional court at the time of remand, followed by the remand order, which indicates that the grounds of arrest were explained, would be insufficient compliance of section 43B of the UAPA. Now, first is, Lordship, they were not given grounds of arrest. Lordship, this is not related to friends or relatives. And 43B, as far as concerned, Lordship, that Lordship already knows relating to them, Lordship, equate to 47, not to 48.
Okay. Learned Additional Public Prosecutor has also submits that the facts in the case of Ahmed Mansoor and others versus state within bracket Supra are distinguishable from the facts of the instant case, in as much as that facts relates, in as much as the case of Ahmad Mansoor and others relates no facts revolves around non-compliance of Section 43B of Unlawful Activities Prevention Act 1967, which is in pari materia with Section 47 of the BNSS. Therefore, he submits that reliance on the aforesaid ruling in this case by the learned counsel for petitioner is not justified. Stop. On the aforesaid, he accordingly submits that considering the nature of the offense and quantity of the contraband involved in this case, the bail may not be granted to the petitioners. I have considered the submissions made by learned counsel for both sides and have gone through the scanned copy of the records of NDPS case number 70/2025, which has been requisitioned in connection with this bail application. Yate Rakhaidev. Remaining, I will dictate in chamber after going through today itself.
The only aspect that even if we assume everything to be true, Lordship, that whether the WT message fulfills the requirement or not, that your Lordship.
Okay.
All right.
Please, Your Lordship. Your Lordship, on previous occasion, we were asked to procure the information regarding the intimation of arrest, Your Lordship. However, Your Lordship, we could not contact the IO as he is out of station. Your Lordship, further 2 to 3 days may be granted, Your Lordship, for procuring the information. It may be taken up on Tuesday, Your Lordship, the matter.
Okay. Heard Miss, what is your name?
P. Upadhyay, Your Lordship.
Heard Mr. K. Thakur, learned counsel for the petitioner. Also heard Miss P. Upadhyay, learned counsel appearing for NCB, who submits that since the investigating officer of the case is on leave, they could not procure the information regarding
The intimation of arrest, Your Lordship.
regarding the intimation of arrest of the petitioner in this case. And she seeks a short adjournment to do the same. Considering the submissions made by learned counsel, the prayer is allowed. Let this matter be listed on Thursday.
Lordship, otherwise, Lordship, the document available in the record, Lordship, at present stage, there is no such, Lordship.
No, let them find out Thursday. Thursday is 6th of November.
Can it be on 3, Lordship?
3, we have many cases. Let it be on Thursday.
May please, your Lordship, only subject to my your Lordship confidence, my Lord, then the matter be taken up on 7th, my Lord, as we have my learned as a read, my Lord. Today I am also not feeling well, my Lord.
Any objection?
No, not feeling. Yes, given is a concern, my Lord.
Not inconvenient, can it be on my Lord Friday, my Lord, 7/11? 7/11.
7/11.
7.
Okay. Heard Mr. N.C. Das, learned senior counsel, assisted by Miss J. Basha, learned counsel for the petitioner
Petition.
who seeks an short adjournment on the ground of his personal difficulty. Stop. Mr. P. J. Saikya, learned Senior Counsel assisted by Mr. A.K. Gupta for learned counsel for the respondent does not raise any objection considering the ground shown by the learned counsel for the petitioner. Hence, prayer is allowed. Let this matter be listed on 7th of November.
Published, your lordship.
Please, your lordship. This is an appeal under section 23 of the Railway Claims Tribunal Act. Lordship may need to issue notice and admit it for hearing and call for the SPI.
Heard Mr. K. Jain. K. Jain,
Lordship.
learned counsel for the appellant. This appeal under section 23 of the Railway Claims Tribunal Act 1987 has been preferred by the appellant, impugning the judgment and order dated 16/6/2025 passed in review application number 0900090/2023 in connection with original application number within bracket Roman 3/GHY/05/2012, whereby the claim of the present appellant was rejected. Claim was rejected. Rejected. Issue notice to the respondent. You have served the notice.
Lordship, to deputy SC.
Since the appellant has already served the notice on the on the learned deputy SGI appearing for the respondent, no formal notice need to be issued to the respondent. Stop. Let the records of the review application number 0090/2023 as along with the connected original application be called for from the Railway Claims Tribunal, Guwahati. Let this matter be listed after 4 weeks on a date to be fixed by the registry.
Much obliged. Similar order may be passed, Lordship, in this matter.
Same order. Same order. OA Belek Hobo. Notice have been served.
Lordship,
Same order.
and 6 also same, Lordship.
6 also same order. Trial court case number Belek.
Much obliged, Lordship. 7.
They filed the objection, my lord.
But where is the objector?
Or otherwise, my lord, this matter will take some time. It will be taken up on a hearing day on 6th November. Because it was-
Now it is ready for hearing.
is ready for it,
We'll admit it and fix it for hearing on
6th November. my lord.
3rd week.
Because the matter before the recovery is in first week of December.
So
So
still we can, instead of, because we have many cases fixed on 6th.
it can be taken up in the admission stage itself, my lord.
On 18th November, we'll fix it, we'll admit it for hearing. Heard Mr. S. Learned counsel for the petitioner. None has appeared for the respondent on call. It appears from record that the respondent side has submitted their affidavit in opposition. Stop this revision petition.
They are here.
Yes, show the name of Miss S. Yasmin for respondent. this revision petition is admitted for hearing. Let this be listed for hearing on 18th of November.
I may be permitted on that day, there's 5 days or positive time to upgrade the matter on 18th matter. Because
No, that liberty is always there. You can mention. There is no bar, but whether it will be allowed or not, that is, but you can mention on that day.
May I please? My lord, in this case, my lord, the petitioner before your lordship filed one title suit for specific performance, my lord, of a contract. And he got judgment and my lord, everything he got, my lord. Court also executed, my lord, the deed sale deed in his favor. Thereafter possession was also given to him, my lord. Thereafter, my lord, one of the sisters of my defendant, my lord, who sold land to me, came, my lord. Her petition was dismissed, my lord. He came against the execution of
After execution.
after execution. Then, my lord, no, my lord, appeal was filed, no revision was filed. Then another sister came, my lord. And in that, my lord, petition filed by, my lord, another sister, learned, my lord, trial court passed the order, my lord, status quo antique, my lord. Removed me, my lord, from the land, my lord, and she was put to the disputed land. Therefore, this honorable court, my lord, was satisfied, my lord. State the order, my lord. My learned friends preparing God.
Now you are in possession,
No, no, my lord,
or you are removed.
tax is
No,
different, my lord.
I'll come to you.
Tax is
According,
different, my lord.
according to him. Now you are in possession of this woodland.
My lord, legally I am in possession, but with the learned trial court, have not passed, my lord, any necessary order after stay order of this honorable court, my lord.
Land is a agricultural land or
No,
homestead land.
Homestead.
So are you in possession now?
Actually, I am not in possession, my lord, because
Okay.
trial court given the order, my lord, to give possession to that sister, my lord, partially, my lord.
Okay, yes, Mr. Ghosh. What is the fact?
My lord, fact is that, my lord, the petitioner herein filed a suit for specific performance of contract against one of the co-legal heirs. That is, one of the brothers of the respondent, as well as other respondents. The property was,
The contract was between whom? Original contract?
original contract was with one brother and him,
Okay.
and we are not party. in
But the
suit.
property is a joint property.
Joint property. We are not party in the suit. So when we are not party in the suit, when execution case has been filed, I, being the third party, I filed an application under Order 21, Rule 97, 98, and 101. That during that proceeding, my lord, I have filed another application for, though I have filed under 151, but it is a petition under Order 21, Rule 45. Two petition has been filed. One miscase number is 119. It is Order 21, Rule 43. Though it is mentioned 151 for attachment of the property. Another miscase, my lord, 111 of 2025. It is under Order 21, Rule 97, 98, 100, and 101. Now, after filing these two applications, in 119, attachment order was passed on 18/6/2025, which is the impugned in the present case. And against 111 of 2025, the case is at the stage of evidence. Because it is a suit, my lord, like a suit, my lord. So it is at the evidence stage. We have challenged the attachment order before this honorable court. Kindly see the IA, my lord, and prayer in this civil division petition. Prayer in this civil division petition. First, kindly go through. Prayer of the civil division petition. Lordship,
Just
basically, he has challenged 18/6/2025 order. Lordship, got it.
just
Kindly go through the prayer, my lord. And in the interim prayer also kindly see in that petition, my lord. Interim part. Last part of the prayer.
yes.
First, basically, he has challenged 18/6/2025, but he has prayed for stay of the miss case number 111111 of 2025 also. Though he has not challenged, because that challenging does not arise, it is at the evidence stage. And then, my lord, he surreptitiously filed one IA, my lord. Kindly see the first order in this CRP, first order. This honorable court has rightly issued notice saying that operation of the impugned order dated 18/6/2005 in so far miss case number 119 of 2025 is state. Lordship, got it? That is attachment order is state. Now, an IA has been filed. Kindly see the IA. IA to dispose of IA. What happened? In the IA, the stay has been granted with respect to the
Execution case.
not execution case.
That
111
your order 2197 petition.
Yes.
Oh,
Main prayer is one thing.
how that can be stated?
How can that can be stated? This is one aspect. Another aspect, my lord, in with respect to civil division petition, my lord, kindly see order 21 rule 45, my lord. Impugned order is page 87, my lord. Kindly see page 87, then order 21, my lord. Page 87, kindly. Impugned order. Page 87.
Yes,
Got it?
yes.
Today, the case posted for hearing in respect of Jimma petition, seen the content aforesaid, gone through the objection filed by the opposite party to the aforesaid petition.
What this Jimma petition is?
Actually,
It is the
attachment
attachment.
order. Attachment order has attachment.
Okay.
Petition was for attachment. The case of the petitioner appears to be that court did not pass any order in the judgment for delivery of possession of houses of the judgment debtor to the decree holder. So the decree holder has no right to enter into inherited house of the judgment debtor as well as petitioner and destroy their properties unnecessarily, but during pendency of miss case number 111 of 2025, Lordship got it.
Yes.
This is in the IA, it has been stated. The decree holder very illegally entered into the residential house of the petitioner and judgment debtor and throw away all the valuable articles from the house and keep in the nearest grace of the judgment debtor in a very wrong condition. Removing the car of the judgment debtor from the garage and some other valuable article also thrown away on some open places outside the house, that the matter is urgent as it is a rainy season And if those valuable items are kept outside the residential room, it will be destroyed by him. Hence, the petition prayed for pass an order directing the Nazir and police to collect key so-and-so, keep household article of the judgment debtor and petitioner inside the residential house, and also keep the car of the judgment inside the garage, and also give Jimma of the listed item as well as residential house of the judgment debtor, and to hand over the key of the judgment debtor and the petitioner. Par contra, the case of the opposite party appears to be that the instant petition is filed with mala fide intention and without any legal basis. That keeping the materials and the car of the judgment debtor in the decretal land is against the spirit of the decree and principle of justice, law and equity. Such an order will have the effect to nullify the decree, and the executing court has no jurisdiction to go beyond the decree, nullify the decree. Hence, the opposite party prayed for rejection of petition. Then, upon perusal and after hearing, it appears that the fate of the residential house standing over the decretal land is not decided by the learned trial court in his impugned judgment. Further, the materials available on record also disclose that good article kept inside the house does not belong to the decree holder. However, the same is kept in the garage under lock and key, situated over the decretal land and in the custody of one Sajal Devnath, Papa Devnath and Hirakpal. Now, as the goods article kept in the garage are household items which are likely to get damaged over the period of time due to lack of maintenance, etc. So, in order to preserve the aforesaid movable property and in order to secure the end of justice, I deem it fit and proper to direct Nazir of the court to shift the same in the residential house situated over the decretal land and keep the same in custody till disposal of this case number 111 of 2025, arising out of title execution number so and so. Needless to say that judgment debtor or owner of the property shall have the liberty to inspect the goods at the regular interval and shall have authority to take necessary steps for maintenance of the aforesaid household goods, movable properties. However, with the leave of
Who had filed this petition under 20?
I have the third party.
Third
one of
party.
these-
But you are not the judgment debtor.
I am not the judgment.
So while the court is referring to judgment debtor, whom it is referring, you or the actual judgment debtor?
Actual judgment.
So your goods were not,
My lord, it is a joint property, my lord, because one possession, it will come, my lord, during when the case of 111 of 2025 will
decided.
be decided. Because I am married daughter. So my possession is constructive possession is there. So it will come in 111. It is not the question. Here in only question is that
who filed the application for attachment? You?
I.
What was the prayer?
they are, yes, kindly see the petition, my lord. Prayer is, my lord.
Page number?
My lord, before that order, my lord, the
Before
honorable court did not pass any order of the judgment, delivery of possession. Last.
What was the
My
prayer?
lord, page 77. Page 77. Last, to direct the police and Nazir of the court to keep all the belonging of judgment debtor and petitioner inside the house and to attach the house and hand over the key before the honorable court till disposal of miscase number so and so. Lordship got it. Internal page P3.
Yes. Your petitioner is the married daughter.
Yes.
Petitioner's belongings were not there in the suit property.
No.
Yes. Support. Cannot.
No, that will come, my lord. That will come. That will come, my lord. My lord, now let
And
us,
judgment debtor has not filed this application.
no. It is filed by the this present petitioner in 111 of 2025 also. Third party. Now kindly order 21, my lord. Order 21, rule 58 kindly. see. Lordship got it. Adjudication of claim to or objection to attach or property. And they have also filed in this application, my lord, objection file. Order 21, rule 58. Lordship got it.
Yes.
Kindly see, this is regarding adjudication of claim to or objection attached or property. Sub rule 4 kindly see.
Yes.
Where any claim or objection has been adjudicated upon under this rule, the order made thereon shall have the same force and be subject to the same condition as to appeal or otherwise as if it were a decree.
No, read 58(1).
Yes, 1. Where any claim is preferred to or any objection is made to the attachment of any property attached in execution of a decree on the ground that such property is not liable to such attachment.
But where is the attachment order in this
This is
case?
the attachment order. I have read. It was attachment.
Your application was under order 21, rule 45.
I have mentioned order only 151 million. But application is under this provision, you know, because it is in execution proceeding, my lord. Then goods so and so local inhabitant locally before the shifting the same residential house shall follow the procedure as prescribed under rule in the Nazir shall also videograph of all undertake pursuant to this order with the above observation direction matter is disposed of.
Where in the decree? Yes,
Now,
what is the subject?
my question is, once this order has been passed under this provision, it is an available order. One aspect. Another aspect, my lord,
But there is no indication that order
indication
had.
that it was attached.
it
But
was-
there, kindly see the last,
And neither there is an indication that it was passed under order 21, rule 58.
Yes.
Neither your petition was,
allowed,
no, has mentioned the provision of law under which.
no. No. Now it may remanded, there will be no, but in so far with respect to stay of the 111 petition is concerned, my lord, that cannot be, my lord. Because neither it was under challenge, nor it can be challenged. Because I will show the one Supreme Court judgment. It is a different court. It is a separate court. So it will follow the under order 21, split of the order 21, rule 97, 98, 100 and 101.
Okay, okay. On what ground you are, you have filed this? Or you have challenged the impugn order?
Where first petition, my lord.
Which,
First
which,
application, my lord. I, my lord, did not approach, my lord, because that may be considered as per law, my lord. Then I will see after result, my lord. I did not object, my lord. Then second, another application filed, my lord, playing, my lord, injunction, my lord. And he got, my lord, she got, my lord, to maintain status quo, my lord. Because I am in possession, my lord, need not be, my lord, disturbed, my lord. Let us try, my lord, in the trial. But third petition, my lord, he filed, my lord, 119, my lord. For here, my lord, it was prayed to vacate me, my lord, and enter her, my lord. And it was allowed, my lord. And this is, my lord, subject to the worship's, my lord, opinion, my lord. This is not at all, my lord, permissible. Because following due process of law, my lord, I was given, my lord.
because 111 is still pending.
Yes, my lord. 111, my lord, and there.
And stay order has been granted by this honorable court.
No, that is, we'll come to that. But why in 119 this order of attachment was passed without deciding 111? What is your submission?
My lord, that cannot be, because, my lord, following due process of, my lord, court, my lord, given me the possession, my lord. Lordship, kindly will look just shortly, my lord, page 42, my lord. Just, I'm showing glimpse, my lord, shortly. 42, my lord, one petition filed, my lord. My lord, they are, my lord, in conspiracy, my lord. Allowed him to sell out the land, my lord, and now they are, my lord, playing tricks, my lord. One sister, my lord, page 42, my lord, Rita Bhattacharya, my lord. And money divided by them, my lord. After selling the land, my lord, they have come, my lord, taking, my lord, differently. And her application was rejected.
No, we are not going to
Yes, my
those
lord, not
questions.
necessary, my lord. Now, my lord, Lordship, kindly will look.
You just satisfy the court on what ground we are challenging the
Yes, my lord.
order
Now,
dated
my lord,
18/6.
the order by which, my lord, I was given, my lord, possession of the land, my lord. Page 45, my lord, just I am showing the relevant portion, my lord. Parties are, page 45, parties are represented, read for delivery of possession has been returned along with report of the civil, wherein it is stated that the delivery of possession of the degraded land has been delivered to the degree holder on so and so, so and so. Now, my lordship, kindly will look, this is the report of the Nazir, my lord, page 46. Delivery was given with police, etc., my lord. Now it is 27, it is report 27/5 report. Now, my lord, this petition, my lord, file, my lord, 111, my lord, she filed this petition. And my lord, I have even not annexed its order, my lord, because she may try, my lord, that petition. Now, lordship, my lord, she filed another, my lord, getting chance, my lord, she filed another case, my lord, page 116, my lord, 116, page 62, my lord. This is her injunction petition, my lord. And here also, my lord, she got status quo, lordship, page relevant, I'm just showing relevant portion, page 76, my lord. Status quo granted. Yes, I am given possession, I am in the house, my lord. She is trying her, my lord, legal right and entitlement, my lord. I did not feel aggrieved, my lord. Let us try, my lord, before the trial court. Status quo granted, my lord. It's okay. Now, my lord, when she got status quo, my lord, she jumped one step ahead, my lord, then filed this petition to vacate me, my lord. Page 77, annexure 14, my lord. And in this case, my lord, serious legal order was passed, my lord. This is page 87, starting the impugn order, my lord. And this, my lord, from the page of the order itself, my lord, lordship, kindly will look. From the judgment holder, the degree debtor she's taking all these things. Well, relevant portion, my lord, page 89, order part, my lord. Kindly, I may be allowed to read out my
Yes.
89, my lord, page. Upon perusal and after hearing, it appears that the fate of the residential house standing over the degraded land is not decided by the learned trial court in his impugned judgment. Furthermore, the materials available on record also disclose that the goods article kept inside the house does not belong to the degree holder. However, the same is kept in the garage under lock and key situated over the degraded land and in the custody of one Sajal Devnath, Bapon Devnath and Hirak Pal. Now, as the goods articles kept in the garage are household items which are likely to get damaged over the period of time due to lack of maintenance, etc. So, in order to preserve the aforesaid movable properties and in order to secure the ends of justice, I deem it fit and proper to direct the Nazir of this court to shift the same in the residential house. Now, my lord, from garage to residential house, allowing house situated over the degraded land and keep the same in his custody till disposal of the miscase number original one, my lord. So and so arising out of title agreement. Needless to say that the judgment debtor or the owner of the property shall now, my lord, judge for in favor of my lord, now judgment debtor observing, my lord. Needless to say that the judgment debtor or the owner of the property shall have the liberty to inspect the goods at regular interval and shall have authority to make necessary steps for maintenance of the aforesaid household goods, movable properties, however, with leave of this court. It is also pertinent to mention herein that the Nazir shall prepare an inventory of the goods kept in the garage in the presence of earlier custodians of the goods as well as in presence of two local inhabitants of the locality before shifting the same to the residential house and shall follow all the procedure as prescribed under rules for the same. The Nazir shall also videograph.
Now, where are the goods now?
Courts, my lord,
In the garage.
then personally, my lord, the
My lord,
learned judge, my lord,
In
threatened the
in my
petitioner.
petition, I have specifically stated these goods are belongs to me. In paragraph 3,
Okay.
2 and 3.
Now, what is the illegality?
Illegality, yeah, my lord, as my lord petitioner was given the my lord, possession of the land, my lord, following one judgment passed by the trial court, my lord. Then if, my lord, one person has come, my lord, for against the, my lord, this degree judgment, my lord, that may be, my lord, disposed of in accordance with law, my lord. But it was not necessary to take, my lord, back the, my lord, possession which was given, my lord, following due process of law, my lord. From the first order and second order, my lord, that may be
No, the possession is still with you.
No, it was, my lord, it was when, my lord, he was allowed to enter in the house, my lord, and it was already lock and key under, my lord, it is sealed, my lord.
Only in respect of the goods which were
Yes,
there.
my lord.
Actually,
But
sealed it,
practically-
which was executed, my lord, with respect to land only,
Yes, my lord, land.
not house. And in the agreement, all these things
My lord,
also.
it was also
I
allowed,
cannot
my lord,
say.
to, my lord, and-
Because I am the third party, that is I only pointing out that there's land.
No, no,
Only
before I'll come back to you. What is the illegality?
we are purchasing the house, my lord, land and house, my lord. And it, as per, my lord, the schedule also, there is a standing house is also there. Then, my lord, when, my lord, any third party who are not originally in the possession, my lord, as per, my lord, provision, my lord, to filing such kind of petition, my lord, that person must be in possession of the land, my lord. Otherwise, my lord, she file case and it will be considered as per law, that's okay, my lord. But here, my lord, when she was not at all in the scene, my lord, and on behalf of, my lord, judgment debtor, my lord, she has suddenly come and, my lord, vacating, my lord, without following due process of law, my lord, and she has got the possession, my lord. And, my lord, in the judgment and in the my pleadings, original cases there, my lord, when I purchased, my lord, this land was also there, my lord, and house was also there, my lord. And now, my lord, vacating me, my lord, their materials are entered, my lord, ultimately, my lord, everything is locked, my lord, and lock and key is under the custody of the court now, my lord. And he is enjoying the, my lord, access, my lord, free access. But now, my lord, after interim order, yes, my lord, this order is stayed, my lord. Perhaps, my lord, here, Learned Court may pass any order, my lord. Earlier, I took instruction, my lord, what happened after interim order. So
Now, what is the status now?
whether after interim order, yes, this order was stayed, my lord. If, my lord, again, my lord, petitioner was allowed to enter, my lord, access in the property, my lord, that instruction. I have
That instruction is necessary.
Case has been stayed, all. 1111 as well as 119.
And my lord, I will satisfy, my lord,
Already
there is a
disposed of.
judgment also, my lord, and provision I will, my lord, satisfy, my lord, the next week, my lord. This kind of work,
Okay, we'll ask for the status as regards the
position.
possession 119, but 111 has to be, stay has to be vacated. 111, there is no justification.
Proceed, my lord.
You are conceding.
Not consider, I will oppose, my lord, obviously, because if entire matter is,
No, if you
For the
concede,
time
it will be easier for me.
my lord,
Otherwise, I am going to vacate it, giving reasons. There is, what is the justification in staying the order 21 rule 97?
If not, my lord, finally, my lord, that case may go, I also may not. But
That
for-
has to be decided.
Yes,
Evidence,
but
I
for
have
the-
laid evidence also in
for
that.
the time being, my lord, the entire proceeding was, my lord, stayed, my lord, like that, my lord. Because the case is going on in the matter, my lord. Therefore, my lord, for the betterment of all, my lord, this if proceeding, the entire proceeding is stayed now. my lord. Basically, 111 is stayed, further proceeding, entire proceeding is stayed, my lord. Okay, all other miscases are filed in this case, my lord. Short date, my lord,
2806 has been disposed of.
28, my lord, that may be, my lord. Yeah,
And
basically,
title execution is,
disposable.
no,
So, no, title execution is still open.
in the title execution, this miscase is going on, 111.
Yes, my lord, tribunal. Short date may be given, my lord, matter may be finally disposed of, my lord. Next week, my lord, any date, my lord.
Heard Mr. A. M. Barbuya, learned counsel for the petitioner. Also heard Mr. S. K. Ghosh, learned counsel for the respondents. This application under Article 227 of the Constitution of India has been filed by the petitioner, namely Pannalal Devnath, impugning the order dated. Where is the impugned order?
18,687.
Page number? Impugning the order dated 18th. Government is also there, party here? No. Okay.
Private.
Order dated 18/6/2025, passed in connection with 119/2025. Passed in connection with miscase number 119. Passed in miscase number 119/2025, arising out of title execution case number 2/2023. Learned counsel for the applicant has submitted that the learned counsel for the petitioner has submitted that the petitioner was given possession of the suit land in execution of the decree for specific performance of contract passed in title suit number, which title suit?
Title suit, my lord, it is TS 16 of 2020, my lord.
Title suit number 16/2020. He submits that after title suit number 2020, who was the defendant in that case?
My lord, her brother, my lord, Amitabh Bhattacharya.
Where the defendant was, what was the last line? He submits that in the said case, the respondent number 2 of the present civil revision petition, namely Amitabh Bhattacharya, was the defendant / judgment debtor.
My lord,
17, na? It was correct, my lord,
not
17.
respondent. Respondent number 2 is another sister,
Amitabh Bhattacharya.
Onindita Choudhury.
No, in this 227, respondent number 2 is Amitabh Bhattacharya only.
How? Only Amitabh Bhattacharya, my lord. This is, my lord,
Petition filed by
case 13, my lord.
Madhumita Bhattacharya and Onindita Choudhury.
No, you go through his 227 application.
He is made party. in
He-
this.
That I'm referring to.
And, my lord, it may be, my lord, it is confusing, my lord. It is corrected 17, TS 17 of 2020, 21, my lord.
পঢ়ক চোন এবাৰ আৰু। Oblique judgment debtor. Judgment debtor. Stop. আগৰ টাইটেল সুট নম্বৰটো কিমান লিখিছে? 17/2021. Stop. It is submitted by learned counsel for the petitioner that the present respondent number 1, namely Madhumita Bhattacharya, who is the sister of the judgment debtor Amitabh Bhattacharya, filed an application under Order 21, Rule 97, 98 and 101 of the Code of Civil Procedure in title execution case number 2/2023. The said petition was registered as Miss Case number 119.
Triple
Wow. Triple one.
2000.
No, 111. Miss Case number 111/2025. And the proceedings of said Miss Case was going on and was at the stage of evidence of the petitioner side at the time of filing of this instant revision petition. He further submits that in the meanwhile, the respondent number 1, namely Madhumita Bhattacharya, had filed an application under Section 151 of the Code of Civil Procedure in
Madhumita Bhattacharya along with Onindita Choudhury. It
but
is
in the petition, her name is not there,
in
page 77.
and this is this copy, my lord, sir.
Page 77 of the
Of
this
of the subject.
of their, you don't have a copy of that. You have not received.
But in my petition, my lord, in certified copy, it is there that two, Onindita Chaudhary and Madhu.
Originally, there are two petitioners, my lord, in the 111, my lord,
Now in 119, there is only one petitioner.
only one.
Yes.
In 119, only
119.
Madhu. I'm mentioning about 119. क्या लिखा? (151) of the Code of Civil Procedure. Inter alia alleging that in the residence in the house in the house situated over the suit land, the valuable articles of the said petitioner within bracket respondent number 1 of the instant case were there, and same were removed from the house by the present petitioner, said house by the present petitioner, and kept in garage. And a prayer was made by the said petitioner for directing the police and Nazir of the court to keep all the belonging of the judgment debtor and the petitioner inside the house and to attach the house. Learned counsel for the petitioner submits that on the basis of the said application filed by the respondent number 1 under section 115 slash section 151 of the CPC, Miss case number 119/2025 was registered, and the impugn order was passed in the said Miss case. Stop. He submits that the executing court erred in passing the impugn order, as it has ignored the fact that the possession of the suit land was handed over to the present petitioner in execution of decree passed in title suit number 17/2021. Stop. He further submits that by order dated 26/8/2025, this court had stayed the further proceeding of Miss case number 111/2025 arising out of title execution case number 2/2023. As well as 119 is also stayed.
Yes,
By which order?
in the main case, my lord. In the main civil litigation.
As well as further proceeding of 119/2025. Stop. On a pointed query posed by this court to the learned counsel for the petitioner as to what is the present status of the suit property after passing of the orders of staying of further proceeding of 11 Miss J case number 111/25 as well as 119/25. He submits that he needs some time to,
My lord, there is an order, my lord, 116 injunction order is there with respect to the suit property. He has annexed in this.
no, 116 is not relevant now,
No, injunction was passed.
but that is not relevant to
Injunction with respect to the suit property.
what injunction?
Injunction status quo with regard to the suit property.
Oh.
When I was there.
It is also submitted by learned counsel for the petitioner that an application under order 39 rule 1 and 2 was filed by the present petitioner,
No. We have filed.
was filed by the respondent in the title execution case number 2/2023, whereby on the basis of which Miss case number 116/2025 was registered. The said Miss case was disposed of by, it has been disposed of or pending.
Yes, disposal, stand disposal, page 76 only.
Said Miss case was disposed of by the court by directing both the parties. Where is the order?
The legal quarter, page 76 only.
Directing both the parties to maintain
Degree holder, opposite party is restrained from changing the nature.
Oh,
of the-
directing both the parties to preventing both the parties from changing the nature and feature of the suit land, including the house standing thereon, till the disposal of Miss J case number 111/2025. Stop. On this, learned counsel for the petitioner, respondent has submitted that the order impugned in this revision petition has been passed in Miss J case number 119/2025. However, by order dated 26/8/2025, this court has stayed the Miss case number 111/2025, which was not required. On what basis this 111 was stayed?
No challenge,
No, challenge is there, my lord.
no challenge.
Because my lord, as per my understanding, my lord, I took the plea, my lord. She was not in possession. As per my lord rule
Stop.
97,
Stop,
not maintainable, my lord. I
stop.
took plea, my lord.
You, as the, I have gone through the, I have considered the submissions made by learned counsel for both sides and have gone through the records of this case. The instant CRPIO number 340/2025 be listed after 2 weeks. In the meanwhile, the petitioner shall inform this court regarding the present status of the suit land as well as property situated over the suit land on the next date fix. Further, as Miss case number 111/2025 was registered on the basis of an application by the present respondent number 1 and one more person. Who is that person?
Sister,
Another.
One,
sister,
namely Anindita.
my lord, her name is, my lord, one Madhumita, another Anandita Chaudhary.
Namely Anindita Chaudhary, claiming themselves to be the co-owner of the suit property, which was the subject matter of title execution case number 2/2023. This court finds, no justification for staying the proceedings of said miss case number 111/2025. As staying the proceeding of said miss case would neither serve the cause of justice nor is necessary for adjudication of the instant CRPIO. Accordingly, the stay granted on further proceeding of Miss J case number 111/2025 by this court in IA within bracket C/2806/2025 on 26/8/2025 is hereby vacated. The executing court may proceed with the proceedings of Miss case number 111/2025 arising out of title execution case number 2/2023 in its normal course. Let this matter be listed after 2 weeks.
My
My
lord,
lord,
that
may I-
may be, my lord, clarified, my lord, this order page, my lord, 87, this order, my lord, 18/6, stay of order dated 18/6/2025.
That we
Is-
have not stated it. That will remain.
Order is there.
Order is there. This order,
Continue, my lord.
this order would not amount, it is hereby clarified that the stay granted on further proceeding of miss case number 119/2025.
It's order
Mm.
dated
119 is no
Sorry.
longer, it was disposed of case.
order.
The stay granted on the operation of order dated 18/6/2025 in 119/2025 by order dated 28/2025 shall
Continue.
continue,
Till next day.
Dispose of this order.
shall continue till
Till
the
next.
till next date.
One for prayer, my lord. The steps which has taken, it is lying with the registry. May I permitted to take one copy, my lord? Steps taken by them.
You need the memo of petition.
Ev-
But
every-
it is like the rest. But I took, my lord, steps, my lord, but it was still in the record, my lord. He may withdraw, my lord.
Okay,
I may be allowed to take one.
you take it. Order is required.
Yes.
Or-
The
Order,
petitioner,
otherwise.
the respondent, the learned counsel for the respondent is allowed to take the copy of
Notice.
notice as well as copy of petition filed by the petitioner, which is lying in the case record as lying in the case record. Stop. The registry to furnish the same to the learned counsel for the respondent.
Obliged.
Worship, in this case, actually, it should be listed for admission, this matter, because the other sides have already appeared. But today, though their name is shown in the cause list, they are not here. The,
We'll fix it for admission.
yes, sir. Next week, if it is possible.
Next week, it will be difficult. Second week of November. Next to next week.
Except for 10th, your lordship, I will be out of station, my lord.
Then third week, in between 18 to 22. 18 to 22.
14th, your lordship, the date may be fixed.
Okay. Heard Mr.
Yep, sir.
A. Bishwas, learned counsel for the appellant / petitioner. CRPIO is also there. / petitioner, common order hoga do tate. None has appeared for the respondent, though name of 2 counsels have been shown in the cause list as engaged counsel for the respondent. Learned counsel for the petitioner submits that this case is ready for admission hearing. What are you challenging?
This is a application, I was
Injunction.
the plaintiff,
Injunction order.
not injunction. I was the plaintiff and application under section 8 was filed of the Arbitration Act, which was allowed, and my plaint was returned. So, on that issue, Your Lord.
Okay. For admission, let this matter be listed for, let it be on a hearing date, 18th, 18 November. Let this matter be listed for admission hearing on 18th of November.
Highly obliged.
14.
This matter, we are not going to press, my lord. This matter may be disposed of. Because since this matter, the lower court has come up for final hearing. And just because of this pendency, the matter is not being disposed of. So I've got an email from my client, my lord.
What relief is sought for?
We had filed one application for a survey commission, which was allowed. They have challenged it. So we do not want that survey commission.
Okay. Heard. Then on concession that can be set aside.
My lord, it can be closed, my lord. Basically, we do not want it because we don't want the matter to linger now because it has come up for final disposal.
No,
fact is
which
like
may be closed, this
My lord,
CRPIO.
This CRPIO.
It has to be allowed, my lord.
If it is closed, then survey commission will be.
Yes, it has to be allowed.
Well, whatever, my lord, on the, on instructions from client.
What happened, my lord, the suit they have filed.
No, it is CRPIO 227.
Ah.
So there has to be some error in the impugned order. It cannot be allowed on concession. You can file an application that you are not pressing for before the trial court.
Will not press my verbal submission and the email is there, my lord, that can be recorded and disposed of.
No, not pressing.
Okay, well.
If
We'll
it
file
is
another.
brought on record by way of an affidavit, my lord, the instruction, I think that will serve the purpose, my lord. That-
No, I am not on that. I am accepting his oral submission also.
Okay.
But suppose if he is, how will we allow the,
Will,
My lord,
you are
Basically-
you are challenging the,
no, I am challenging, my lord.
yes, you are challenging the impugned order on the
Yes.
ground of some
Yes,
illegality.
what is the illegality? Just briefly, I am telling, my lord. My lord, the respondent filed a suit against the defendant, stating, claiming declaration of right title in.
Where is the impugned order?
My lord, impugned order starts at page 60. Before coming to that, my lord, lordship kindly the background, my lord.
No, let me go through the page 60. You can file an application before the trial court
Well-
that we don't want.
my lord, that liberty may be granted and disposed of.
Yes.
Well.
Otherwise, we have to say something about the correctness of the order.
No, my lord.
There was no prayer in the suit. That lordship may.
No,
there was-
let us not go into
Okay,
the
okay.
My lord.
correctness. Heard. Mr.
Chakravarti.
P. Chakravarti, A. Chakravarti, T for Tiger.
ST for type.
Heard Mr. T. Chakraborty, learned counsel for the petitioner. Also heard Mr. A. Sahewala, learned counsel for respondent number
1 to 3, my lord.
1 to 3. Only 3 respondents.
Only
are
three.
Learned counsel for the respondent has submitted that this application filed by the petitioner impugning the filed by the petitioner by which he has impugned the order dated 16/8/2024 passed in Ms. J case number 37/2023 arising out of title suit number 12/2022 by which the trial court had allowed the prayer of the present respondent by appointing an commissioner to make a local inspection in respect of the suit land and submit a report thereon. Stop. Learned counsel for the respondent submits that he has been instructed by the learned counsel, by the respondent not to oppose the prayer of the present petitioner. Stop. As the present respondent does not have any objection, even if the civil Nazir, even if the impugned order is set aside and the order of appointment of order of issuance of commission under order 26 of CPC is revoked. Stop. Learned counsel for the petitioner, on the other hand, what is your objection?
I have no objection.
No, against the impugned order.
They have prayed for appointment of a commissioner for the purpose of seeing whether there are any tenants over the suit land. But it is not their case. Their case is only for declaration of right title interest and partition. There is no prayer that they are entitled to mean profit arising out of that suit land. But the object of appointing a commissioner has no relevance with the prayer made in the suit.
Okay. I've heard learned counsel for both sides and considered their submissions. In view of the fact that the present respondent is not opposing the impugned order, this court is not inclined to go into merits of the impugned order passed by the trial court. However, as the learned counsel for the petition, learned counsel for the respondent has sought a liberty from this court to file an application before the trial court indicating that they are not pressing for appointment of appointment of commissioner as directed by the trial court by the impugn order, comma. This civil revision is disposed of with an observation that if an application is filed by the present respondent, who you are the plaintiff,
Of the place.
who is the plaintiff in title suit number, title suit number
Title suit number, the 12 of 2022.
12 of 2022. The क्या लिखा last line?
Next date is fixed on 15/11. Lordship will specify that on that date.
Present respondent before the trial court. Who present respondent who read. 22, comma, before the next date fixed. That is
15th of November.
15th of November. Indicating that he is not pressing for issuance of commission in pursuant to order dated, in pursuant to the impugn order. The trial court shall not insist on compliance of the aforesaid order.
Right.
This revision petition is accordingly disposed of.
Public.
Hello, meet me there, Yolo. It is the service upon the respondents or complaints. The trial court record, the scan copy has also been received now. Let it come up for admission. Madam.
Admission. We'll admit it today. And let it come up for CRPIO. Okay, admission hearing. Heard Mr. A. Deka, learned counsel for the petitioner. Also heard Mr.
DJ Methi for respondent 5 to 7.
DJ Medhi, appearing for respondent number 5 to 7. Also heard Mr. T. Gogoi, TR Gogoi, appearing for respondent number 1, 3, and 4. Who is appearing for 2? You are appearing. You are appearing for all 1, 2, 3, and 4. Appearing for respondent number 1, 2, 3, and 4. Yes. Since the appearance of parties is complete in this case, and since the records of the trial court have already been received, let this matter be listed for admission hearing in the 3rd week of November on a date to be fixed by registry. The interim order shall continue till next day.
16.
And may I please, Lordship, in this case, one says has filed the CRPIO, Lordship. Service of the respondent is complete, Lordship. Respondent number 1 to 7 entered appearance, and as far as Lordship, office note, Lordship, respondent number 8 also, he has also received the copy.
You are appearing for 1 to
My lord, all my lord.
8 also.
Main my lord, we are my lord, 1 to 7.
Heard Miss
My lord,
B.
I have a submission, my lord. I have no objection to allow this petition, my lord, because my lord, they are trying to, my lord, depose before the court, my lord, which was rejected, but we have no objection if their, my lord, deposition is allowed. So, my lord, their prayer may be allowed.
Which is the impugn order?
page 47, initially lordship page 47 lordship. What happened in this case lordship? The respondent number 1 to 7 has filed the title to lordship against the recovery of lordship two shop room lordship.
Recovery of
Shop,
two
shop room.
Shop room from the
shop
tenant.
room, okay.
The title to allow the subsequently they have filed the title execution lordship. But in the execution proceedings lordship, the learned civil tax junior division lordship and requested the lordship the settlement officer lordship to appoint a lordship Amin commission lordship. Accordingly, when the Amin commissioner lordship go to the spot lordship, they found that the land is lordship and the government first land lordship. Accordingly, they filed a application and the title execution case is to state and miss the case 35 is lordship registered lordship. And accordingly, in the miss the case lordship, that we have filed a lordship PW lordship. But due to panchayat election lordship and the land lordship survey not at that time lordship going on. So lordship that the PWs are not present for cross examination. Accordingly, that
The,
is expand lordship.
you have filed application on order 97, order 21, rule 97.
Yes, 97 to 2001, so 101.
97.
101. Okay. When is that stayed?
Stay order.
That is stayed by this court.
180,000.
Okay, he's conceding, we'll allow your application. Heard Miss D.D. Burman, learned senior government, learned senior additional government counsel, Edward, learned additional senior government advocate appearing for the petitioners. Also, Mr. A.M. Bolbhuya appearing for respondent number 1 to 7. On perusal of office note dated 28/10/2025, it appears that notice issued to respondent number 8 by usual mode has returned with a service report of the process server. On perusal of the report of the process server, it appears that the notice was delivered to the nephew of the respondent number 8. Stop. In view of the report of the process server, the notice issued to respondent number 8 is held to be duly served. No one has appeared on call for respondent number 8. Hence, this CRPIO shall proceed ex parte against respondent number 8. This application under Article 227 of the Constitution of India has been filed by the petitioners impugning the order dated 8/4/2025 and 25/4/2025, whereby the Court of Learned Civil Judge Junior Division number 1 Hailakandi, which is the executing court, had rejected the prayer by the present petitioner for allowing them to
Cross the my lord PWs.
you have already submitted to allowing the PWs to face cross-examination. Learned Senior Government Council submits that in the MISJ case number 35/2023, the petitioners have already adduced examination in chief of how many witnesses? 4 witnesses. However, due to panchayat elections which were going on at the relevant point of time, the said witnesses could not appear before the executing court for facing the cross-examination. She submits that the petitioner would be highly prejudiced if the examination in chief of the witnesses for the petitioner is expunged and they are not allowed to face cross-examination. Stop. On the other hand, Mr. A. M. Borgia, learned counsel for the respondent number 1 to 7, submits that considering the grounds shown by the learned counsel for the petitioner, he does not have the respondent number 1 to 7 do not have any objection if the instant civil revision is allowed and the witnesses for the petitioners are allowed to face cross-examination.
At the last time.
This is for the first time.
Previous
I'll
times- times
give
they
a
will-
fixed date. Fixed date. Considering the submissions made by learned counsel, learned senior government advocate for the petitioner and concession given by the learned counsel for the respondent number 1 to 7, as well as considering the fact that ends of justice would be served if the witnesses for the petitioners are allowed to face cross-examination. This CRPIO is disposed of with a direction to the Court of Learned, Munsif number 1, Hailakandi, to allow the witnesses for the petitioner to face cross-examination in Miss Case number 35/2023 on the next date fixed. Stop. It is hereby made clear that no further adjournment may be granted to the petitioner in this regard. Stop. As both the parties are represented by learned counsel for their engaged counsel, the witnesses for the petitioner along with their its witnesses as well as the opposite party decree holder are directed to appear before the Court of Learned Munsif number 1 Hailakandi in Miss Case number 35/2023 in connection with title execution case number 11/2017 on the next on when
On my lord, next, my lord, 14, my lord. 14.
They are also the government officials. lordship.
long time we need because no further adjournment will be granted. You suggested it
17,
November, lordship.
local officer, same office and court are in the same,
21st November,
the same campus, my lord, court and office. the Hailakandi.
21st November. 21st November. This
21st November or my lord, next date fixed in the case, whichever is later. my lord. That would be convenient for
Court has
the
fixed. Court will fix that next date for cross lordship. First date is for appearance lordship, then lordship, the court will fix the next date for. cross.
no on 25th November you appear thereafter whatever court directs. 21st November.
Fine.
This CRPIO is accordingly disposed of.
Matter relates to non-filing of the written statement within a period of 90 days.
Who is for the other side?
As per office note dated 27/10/2000, used its lordship, but AD card neither answered notice of.
We have to ensure this, not
Lordship,
what is to be done.
But in the similar matter, my lord has passed an order wherein my lord in the same instant proceedings, written objection was allowed by my lords. Written objection was also.
But
not
there
granted.
must be heavy costs.
But I leave it to my lord, subject to my lord.
What was the cost imposed?
2000 was imposed. Lord. So, but para number 6 down below. Lord.
No, what is the case?
Lordship, the case between the parties is that we are the defendants here, Lordship. Plaintiff had filed the case stating that we were a tenant under her. And Lordship.
Now, at what stage the case is
It's
pending?
pending at the stage of filing of evidence. It is fixed for evidence, Lordship, but we had paid on the last occasion that already we had filed the WS on record. An attempt was made to consider the same, but the Lordship, the court did not consider. Said that the period of 90 days has lapsed. We are not allowing it. to be-
When is the next date?
Next is the 3rd of November, Lordship, on Monday. itself.
Okay, you,
It's already on record, Lordship. We had made a categorical statement. We have not recollected it also. WS and written objection both are on. And Lordship has considered on the same facts. That is the written objection by paying a cost, the same may be taken on record.
heard Mr. H. Betala. And counsel for the petitioner. On perusal of the office note dated 27/10/2025, it appears that the notices issued to this whole respondent have not returned till date. What is the subject matter?
The subject matter is
Yeah, tenancy.
tenancy, Lordship. They say that they were the tenants under us, Lordship. We never gave them the tenancy rights. It's
Okay.
only my property. Lordship. That is the contention. And the relationship between the
La-
plaintiff and the defendant is that of
learned-
son and father.
Learned counsel for the petitioner has submitted that the instant CRPIO, CRP within bracket IO, has been filed by the petitioners. Impugning the petitioners under Article 227 of the Constitution of India, impugning the order dated 23/6/2025. And what was the order passed on 5/8?
The 5/8, we made an attempt to put the written statement on record, saying that on the last occasion, the medical report was not considered by the court. So we put on record that the medical document was there. So the court again held that.
As well
Lordship
as-
Not accepted.
as well as consequential order passed on 5/8/2025, passed in title suit number 30/2025 by the Court of London, Civil Judge Junior Division number 4. Whereby it rejected the application for accepting the written statement filed by the present petitioner who is the defendant in title suit number aforesaid title suit. On the ground that 90 days have already been expired. Stop. Learned counsel for the petitioner submits that why you could not file it is within due time.
Lordship, that was because of, Lordship will kindly see that there is a medical prescription to quote at page number 20, Lordships. Court says that on the last date when 23/6, I did not produce the document that why this period was lapsed. Lordship may have it at page number 20, order dated 5/8/2025. If I may read, Lordship, the third paragraph, I have perused the petition and the copy of the medical prescription which has issued on 17/6/25. There is no medical document of the defendant dated 23/6/25 showing that she was suffering from all illness and for which she could not contact her engaged advocate. On the last date, the learned advocate for the defendant take the plea that no instruction received from the defendant for which the
Last line. Last line. Have already been lapsed. Stop. Learned counsel for the petitioner has submitted that the petitioner could not file the written statement within the period of 90 days as she had some family emergency and was also having certain health issues. Stop. However, said ground was not taken into consideration by the trial court only because of the fact that the petitioner failed to produce the relevant documents.
So it is on record, 120, page number 120. We had submitted also. At 120 is the medical report also. That says that on 23/6, I had not presented that I was not unable. It says that the fever and other comorbidities that continued till a period of 6-7 days. And there is an entire document, Lordship, that she is already having a prolonged disease from 17 till
Alika.
then.
As well as health issues. In spite of the fact that medical supporting medical documents were also deposited by the petitioner.
Said application is at page 136, Lordship, along
Stop.
with the medical document.
Learned counsel for the petitioner submits that though the written statement filed by the petitioner is lying there on record, it has been submitted on which date?
5th of August 2025.
5th of August
2000.
2025 and lying there on record. The trial court refused to treat it as a part of record by rejecting the prayer for accepting the written statement beyond the period of 90 days. He submits that the petitioner was prevented by genuine cause in filing the written statement within the prescribed period of time. However, as now the written statement is already there in record, if same is not considered, if same is not formally taken on record, the petitioner would be suffering prejudice. He further submits that the petitioner would be suffering prejudice. He further submits that the petitioner is ready to pay cost as a condition precedent for allowing the present application. Stop. I have considered the submissions made by learned counsel for the petitioner. Since the written statement has already been filed before the trial court, comma, though after the period of 90 days, comma, and since the cause for filing the written statement by the petitioner belatedly cannot be totally brushed aside. This court is inclined to allow this civil revision without issuing notice to the respondent. This court is of considered opinion that under the facts and circumstances of this case, as well as for the reasons stated by the petitioner for his failure to submit the written statement within the prescribed period of limitation, comma, the ends of justice would be served only if she is allowed to file written, only if the written statement filed by her is taken on record. Record subject to payment of some cost. Accordingly, this civil revision petition within Vekatayu is hereby allowed with a direction to the trial court to take the written statement filed by the petitioner on record, subject to payment of rupees, how much?
It was 2,000 on that occasion in the written objection. Lordship may impose the same amount.
Subject to payment of rupees 2,000 by the present petitioner before the court. Now, if the said amount is paid, it shall be given to the plaintiff, that is the sole respondent of this case. Stop. It is also made clear that depositing of the cost imposed shall be condition precedent to the taking of the written statement on record by the trial court in pursuant to this order. With above observation, the CRPIO is hereby disposed of.
I'm grateful, Lordship. Deeply obliged.
The father of the petitioner, my lord, filed a revision against the eviction order, my lord. And this revision was admitted and interim order was passed. Then father died, my lord, the petitioner was substituted. Then they have engaged the council, my lord. The council, my lord, failed to appear on many dates. Then, my lord, the petitioners received a notice from the executing court. They filed an execution case, and executing court issued a notice, and that was received on 4/5, my lord. Then only they came to know that something happened. Then they have written to the, my lord, to the advocate. Then advocate, my lord, mentioned that sorry, my lord, he could not inquire. After inquiry, he will call shortly, my lord. That you will also find at page 17, my lord.
No, this I is for
Condolence of delay. Condolence of delay.
restoration.
Yes. Condolence of delay, restoration is a separate, my lord. This is the 131.34 is condolence of delay. Restoration is 20.
Condonation of delay of 2 to 75 days.
My lord. Because the advocate was a fault, my lord. For advocate's fault, I am suffering, my lord. That is why, my lord, I have come.
When the notices were received
Hello?
from the executing court.
4/5, my lord, your lordship may just see my paragraph, my lord. Paragraph 4, my lord. the applicant petitioner states that suddenly on 22/4 so-and-so petitioner received a notice from so-and-so in the execution case number so-and-so whereby next date is fixed so-and-so. Immediately applicant petitioner forwarded notice over WhatsApp advocate who did not respond. Thereafter again on 23/4 applicant petitioner contacted again. No reply was given by the engaged advocate who on 24/4/25 requested that he has to look into the matter and shall get back shortly. Even asked the deponent not to worry about the same. Now that is with me, my lord, that I have a next. That is at page 18, my lord. Page 17. That advocates, my lord, replied. They are outside, my lord, from Hailakandi, my lord. They are fully dependent on, my lord. He has stated, my lord, that he
Yes, Mr. Dekar.
My lord, my lord, I need to make some submission in this matter. First of all, my lord,
Any other submission?
my lord, I can submit, my lord, that the advocate's fault, my lord, it cannot, should not be, my lord. I can just two reasons, my lord, as well as one reason, my lord, however long delay is there, my lord. 25 or 25 or- My lord, first thing, my lord,
What this WhatsApp chat says?
is another aspect, my lord. Then when I received the this, my lord, I again, my lord, send another, there also, my lord, at page 18. That High Court, when High Court order was received, my lord, he said so. বলছিলাম দাদা কাল থেকে তো কোর্ট বন্ধ ক্লোজ মানডে আমি প্লিজ ওর করব ফ্রি হলে কারণ
Okay.
কিছু
Okay. So your
this
case
is
is that your engaged counsel failed to perform.
fail, my lord, several days.
Where is the citation?
Yes,
Only one.
only. Yes, my lord. One is of High Court and one is Supreme Court, my lord. কি করে থাকুন? একটা হয়ে যায়। My lord, one of the High Court decision to put. তো ইমান বলবো হয়ে যাচ্ছে। My lord, that is 1985 Supreme Guwahati 22. Here also it is there. Yes. And just. Your losses, just may director, your losses may see paragraph 6. Supreme Court judgment will consider earlier. Paragraph 5, then 6. Instant case the petitioners came is fairly covered by the aforesaid pronouncement of Supreme Court. Petitioner also comes from a far-flung village in the district of North Lakhimpur and took steps to come to Guwahati all the way from distant village, district law, and filed an application coming to know about the date of his appeal from his lawyer, which was dismissed on account of the lawyer's laches. He should not be penalized for a fault of the lawyer. Being a villager, he may not be aware of the technical nature of the procedure laws. In our opinion, is preeminently fit case where appeal should be restored to the file. Another matter of the hand just.
Okay. Yes, what is the submission?
And still not delay it, my lord, whatever it may be, my lord, 25, my lord, that we are losing.
That's in your complete.
Yes, completed.
Yes, my lord. First of all, my lord, before taking to my objection, my lord, the instant revision against the concurrent findings, they admitted that TNN, my lord. And on both the courts below, my lord, they failed, my lord, regarding the defaulter and bona fide requirement. Trial court is decreed in our favor. I am the plaintiff, my lord. Bona fide requirement defaulter, then they preferred appeal and appellate court, my lord, on the ground of bona fide requirement dismissed their appeal, my lord. Then they preferred revision before this court 2016, my lord. And 2016, 17, 18, 19, after 4 years, this matters, my lord, dismissed for default, my lord. Since 2019 to 2025, they were not away, but they are enjoying our land, my lord, at the TNN, my lord, since then, my lord, on when they received notice as per the paragraph 4 of their application, my lord. they all when received the execution notice, then contacted to the client, my lord. Whereas, my lord, admittedly, my lord, after expiry of the original petitioner, the two sons, that is the petitioner number, that is.
No, when they receive notice.
Yes, my lord, kindly have a look in paragraph 4.
9/4/2020.
Yes, my lord, paragraph 4 and paragraph 5 specifically, I'll read, my lord. Paragraph 4, my lord. With the lordship due permission, I'll have to read again, my lord.
No, don't read.
Yes, my lord. In
Their,
paragraph-
case is that we were not aware about the,
I'm on that point, my lord. First of all, my lord, there is a revision against concurrent findings. There are April
No.
10 and 2016, the preferred.
we are not going into that issue.
2019 were dismissed for default. For 2019 to 2020, but the sitting silent about that. Since it's a revision matter, my lord. Then, my lord, then despite they are having the contact number with their councils, my lord, and they have not contact in between for the last.
Revision was filed by their father.
Their father, my lord, then they are implicated in the matter. They are very much aware this case, my lord. They are very much aware. Why for the more than 6 years they waited for to get the no communication with the client? This is not only one ground they have taken. There's the negligence of the advocate. My lord, this is a very casual ground, my lord. In the all the delay
No,
petition, lord.
after dismissal of the CRP for default,
Yes, my lord, 2019, my lord.
2019.
19. Then
When you file execution case,
2024, my lord.
so how they will come to know?
My lord, then 2019 to 2024, they're sitting silent about they have not cleared about what about their case is there, my lord. See, for the more than 6 years, they're sitting silent about the matter, my lord. More than 6 years, 86 days, my lord. I've counted it, my lord. Then when they receive execution, then file it. And moreover, my lord, paragraph 15(5), they have said that they have lost one written complaint against the council. Where is the written complaint? It is not annexed here, my lord. Only statement made complaint lost against the statement. Whole case is based on against the council, my lord. This is the very, my lord, normally in delay conjunction petition, this ground, clients take always this ground against the blame given to the council. The wife, they are tenant, my lord. They are both the courts, my lord, they fail, my lord. They're enjoying their our
No,
property, my lord.
but the WhatsApp chat,
And my lord, so equitable regarding the delay conjunction, honorable apex court, I will rely, my lord. Kindly have a look on paragraph 4 and 5 of my objection petition. After considering my paragraph 4 and 5, I leave it up to your lordship, my lord. With lordship due permission, I have to read the paragraph 4 and 5, specifically paragraph 4, my lord.
yes.
With due page 25, my lord. That with regard to the statements made in paragraph 3, 4, 5 of the instant interlocutory application filed by the applicant, the deponent vehemently denies the same. The deponent
We will continue.
Yes.
At two.
Yes, my lord.
Yes.
May- My lord, paragraph 4 of my application at page 25.
Yes.
Dada, can come off with that with regard to statements made in paragraph so and so of the instant interlocutory application filed by the applicant, the deponent vehemently denies the same. The deponent further begs to state that the applicant has failed to explain the delay properly. The pleas taken by the applicant are beyond reasonable belief, and the grounds not but flimsy and same cannot be treated as sufficient cause. Merely putting blame on the earlier engaged counsel does not absolve the applicant from the explaining satisfactorily about his gross lapses in remaining not vigilant about his case. That too for the use period of 2,270. Therefore, the delay caused by the applicant is intentional, and the story explained by the applicant is false, concocted, and afterthought one, with a view to get a bona fide benefit of condemnation of delay. Moreover, the applicant had taken himself to file this instant interlocutory application only after getting the notice under Order 21, Rule 12 of the CPC for execution of the judgment and decree that it's so and so entitled suit so and so. Whereby the learned trial court below decreed the suit, and the same is also affirmed by the learned appellate court entitled appeal number so and so. Therefore, as far as the merit of the case is concerned, there remains nothing in support of the applicant as such the instant interlocutory application is nothing but to prolong the matter for the wrongful gain. Moreover, the deponent begs to state that although the applicant has mentioned about the contacting with his earlier engaged counsel continuously for 4 days, such as so 4 days. That too, after receiving the notice from the executing court, but he has absolutely failed to establish that he had ever tried to contact his said counsel to know about the status of his said case, despite having the contact number of the said engaged counsel ever since the matter was dismissed for default in the year of 2019 to 2021 for 2025. Therefore, the applicant was grossly and blatantly negligent about his matter, and he does not deserve any leniency in the matter. Moreover, the nowadays litigants are not dependent on their lawyers to know the status of their cases, as everything is clear visible in the website of the courts. The applicant could have asked the status of the case at least once during the period 2019 to 2025. Therefore, it can also be reasonably presumed that the applicant was very much aware about the dismissal of his matter for default and intentionally avoided to seek remedy in time with a view to wait for a receiving notice from the executing court with a dilatory tactics to enjoy the suit premises of the deponent for more time. Now, when the such notice is finally issued, the applicant is feeling ignorance about the dismissal for default. That's because he is very much aware about the merit of the case. Therefore, the reason cited by the applicant cannot be termed as sufficient reason which prevented him from the filing the instant interlocutory application for condemnation of delay in the restoration of CRP paragraph 5 minute. That with regard to the statement made in paragraph 6 to 8, the instant interlocutory application filed by the applicant, deponent vehemently denies the same. The deponent begs to submit that the applicant had narrated some false and concocted story in order to get benefit for condemnation of delay of dated days, which is unprecedented and occurred only because of the gross negligence on the part of the applicant. The Honorable Apex Court in the case reported 2005 SSC 2010 that Property State of India's Staff Association has held it. Para 9 Milord. The rules of limitation are not meant to destroy the rights of the parties. They are meant to see that the parties do not resort to dilatory tactics, but seek their remedy promptly. The object of providing a legal remedy is to repair the damage caused by the reasons for legal injury. The law of limitation fixes a lifespan for the such legal remedy for the redress of the legal injury so suffered. The time precious and wasted time would never revisit. During the efflux of time, the newer causes would sprout up, necessitating the newer persons to seek legal remedy by approaching the courts. So a lifespan must be fixed for each remedy. Unending period for launching the remedy may lead to unending uncertainty and consequential anarchy. The law of limitation is thus founded on public policy. It is enshrined in the maxim interest republicus ad sit finis litigam. It is for the general welfare that a period be put to litigation. The idea is that every legal remedy must be kept alive for legislatively fixed period of time. Furthermore, the principle governing the condonation of delay is that each day delay has to be explained properly, satisfactorily, and convincingly, and the delay cannot be condoned merely on sympathetic ground. When mandatory provision is not complied with, as held by the Honorable Apex Court in reported 2007 to SSC 2 Gopinath Pillai for the state of Kerala, and another case reported in 1998 SSC P.K. Ramachandran versus in Kerala. 6. The law of limitation may harshly affect a particular party, but it has to be applied with its all rigor with the statute so prescribed, and the courts have no power to extend the period of limitation on equitable grounds. The deponent begs to submit that there was no sufficient cause for this unprecedented delay, and the applicant was grossly negligent, eventually not acting diligently, and here in the instant case, no satisfactory explanation has been given regarding the delay caused to the law of limitation, has to be applied with all its rigor provided by the statute, and the courts have no power to extend period of limitation on equitable grounds as observed by the Honorable Apex Court 2013-14 SSC 81, that is Best Varaza, another special land acquisition, so relevant paragraph of which quoted below. Paragraph 2, 12 below. It is settled legal proposition that the law of limitation may harshly affect a particular party, but it has to be applied with all the rigor when the statute is so prescribed. The court has no power to extend the period of limitation on equitable grounds. A result flowing from the statutory provisions is never evil. A court has no power to ignore that the provisions to relieve what it considers a distress resulting from its operation. The statutory provision may cause hardship or inconvenience to a particular party, but the court has no choice but to enforce it, giving full effect to the same. the legal maxim, the law is hard, but it is the law, stands attracted in the such a situation. It has consistently been held that inconvenience is not a decisive factor to be considered while interpreting a statute. The statute of the limitation is founded on a public policy, its aim being to secure peace in the community, to suppress fraud and perjury, and quicken the diligence and to prevent oppression. It seeks to bury all the facts and past which have not been agitated by unexplainably and have been lapses time-bound become stale. Moreover, it has been very much clear what the applicant was all along negligence. There is want of bona fide on his part, and he has not acted diligently, and it is quite unbelievable that the litigants remain inactive for the almost 7 years, and no satisfactory explanation has been given except putting blame on the advocate. Whereas the Honorable Apex Court held that while condoning a huge delay, recording of satisfactory explanation is a prerequisite. As such, the instant interlocutory application is liable to be rejected. My lord, only one citation I like to place, your lordship, similarly covered in this case, my lord. 2024 latest judgment passed by the Honorable Apex Court. It is 2024 SSC online, Supreme Court 3380. The party's name is Milo, Rajneesh Kumar and another
Paragraph.
Paragraph 356, the facts and law discuss paragraph 10, 11, 12. Paragraph 3, my lord.
No, read only 10, 11, 12.
Okay, my lord. My lord, my case is also same covered, my lord. In this case also, my lord, this dismissed for default, my lord. Then he preferred appeal against default order. Then appellate court, the ground taken by the plaintiff on the allegation against the advocate. Then appellate court is allowed on that ground, my lord, putting a allegation against the advocate. Then party approached before the High Court. High Court rejected that plea. You cannot blame to the advocate solely. Then he again approached the Supreme Court. Then Supreme Court's finding this is paragraph 10, 11, and 12. It appears that the entire blame has been thrown on the head of the advocate who was appearing for the petitioner in the trial court. We have noticed over a period of time a tendency on the part of the litigants to blame their lawyers of negligence and carelessness in attending the proceedings before the court. Even if we assume for a moment that the concerned lawyer was careless or negligent, this is itself cannot be a ground to condone long and inordinate delay, as the litigant owes a duty to be vigilant of his own rights and is expected to be equally vigilant about the judicial proceeding pending in the court litigated in this instance. The litigants therefore should not be permitted to throw the entire blame on the head of the advocate and thereby disown him at the time and seek relief. In the aforesaid context, we may refer to a decision of this court in the case of Solil Dattapasa TMMC Private Limited Censure, para 8, my lord. The advocate is the agent of the party. His acts and statements made within the limits of authority given to him are the acts and statement of the principal, that is the party who engaged him. It is true that in certain situations, the court may, in the interest of justice, set aside the dismissal order or an ex parte decree, notwithstanding the negligence and or misdemeanor of the advocate, where it finds that the client was an innocent litigant, but there is no such absolute rule that a party can disown his advocate at any time and seek relief. No such absolute immunity can be recognized. Such an absolute rule would make the working of the system extremely difficult. The observation made in Rafik Censure must not be understood as an absolute proposition. As we have mentioned herein above, this was an ongoing suit posted for a final hearing, and after lapse of 7 years of its institution, it was not a second appeal filed by the villagers residing away from the city, where the court is located. The defendant is also not a rustic ignorant villagers, but a private limited company with its head office at Calcutta itself and managed by the educated businessmen who know where their interest lies. It is evident that when their application were not deposed before the taking up the suit for final hearing, the fate of the refuse to appear before the court. Maybe it was part of their delaying tactics as alleged by the plaintiff. Maybe not, but one thing is clear. They choose to non-cooperate with the court. Having adopted such a stand towards the court, the defendant has no right to ask his indulgence, putting the entire blame upon the advocate and trying to make it out as if they were totally unaware of the nature and significance of the proceedings is a theory which cannot be accepted and ought not to have been accepted. My last paragraph, my lord. 12. As regards the law of limitation, we may refer to the decision of this court in Bharat Barrel vs. Drum, MFG Go, and Employees of State Insurance Company, 1971 findings, my lord. The necessity for enacting periods of limitation is to ensure that the actions are commenced within the particular period. Firstly, to assure the availability of evidence, documentary as well as the oral, to enable the defendant to contest the claim against him. Secondly, to give effect to the principle that law does not assist the person who is inactive and sleeps over his rights by allowing them, when challenged or disputed, to remain dormant without asserting them in the court of law. The principle which formed the basis of this rule is expressed in the maxim vigilant of non-dormitus jura subveniat. The laws give help to those who are watchful and not to those who sleep. Therefore, the object of the statutes of limitation is to compel a person to exercise his right of acting within the reasonable time, as also discourage and suppress act and fake and fraudulent claim. In view of the aforesaid, we find no error in the findings of the Impian Final High Court and warrant in so and so, ultimately not considered. So, my lord, similar circumstances also mine in this case, my lord. There, my lord, they are a businessman, my lord. They are not villagers. They are very aware of their stand, my lord. They filed what the courts below, they failed that before revision 2016, 2019, this matter was dismissed for default. Since 2019 to 2025, they are sleeping over the matter. Suddenly, when they received, they have admitted in a paragraph 4, after receivable execution notice, then they contacted their counsel, and then accordingly they filed before my humble sums in this case, my lord. This honorable Apex Court had categorically similar ground. This Apex Court had already discussed on this point. May I putting an allegation against the advocate, he cannot take the benefit of the Section 5 of the Limitation Act. My humble assumption that had them, the petitioner would have taken some other ground, some other bona fide or genuine ground, then court would have exercised his right of equitable right provided against them. But here, my lord, that not at all. They are tenants. Both the courts will they fail on the ground of bona fide ground and defaulter ground, my lord. Then they prefer civil revision 2016 file, 2094 years they are enjoying our property. Then thereafter they're sitting silent, they are enjoying our property, my lord. And 2025, they have waited to get the notice from the executing court. Then they preferred. Is this a ground for consideration? Is there sufficient cause explained in the application? No, my lord.
One query to you, Mr. To the petitioner's counsel. You have to assist the court in the reading annexure 4.
Yes,
What is that?
well,
Please RCV the,
well,
what is,
my lord, he replied, don't worry, I am extremely busy. ওবার থাকলে আপনার ইস্যুটা দেখতে পারিনি. He could not see it. Sorry for, without fail, call করবো shortly. Immediately he will call it, my lord. He will look into the matter. Second one also same, my lord. My lord, here what happened? And paragraph 3, I have said that
no, what is the second one, green?
he written, my lord, don't worry. I am
No,
there.
in
I will busy.
page 18.
Yes, 18 also, my lord. বলছিলাম দাদা কাল থেকে কোর্ট ক্লোজড মানডে আপনি ক্লাস অফ করবো খবর করবো ফ্রি হলে তো কারণ কিছু তো বোঝা যাবে করছে না কেসে ওটাও তো ঠিক নেই তো খুব বিজি তো ছিলাম করছি না আপনাকে বাট আপনি তো বলতে আপনার
Okay, no, this message is by you to your counsel and counsel was not responding. Is it your case?
My lord, yes, my para 3, I have said continuously, I am communicating with the engaged counsel. My lord, he said that the case is pending. In para 3, I have said.
Okay, any reply?
My lord,
Anything else you have to?
and moreover, my lord, in that High Court case, my lord, the Supreme Court case has been delayed on 85 1cc. That is, there was 6 years delay. Your losses may see the para 3 of the High Court case. I need to look at it. The loss will see. Primary question is whether default or carelessness or negligence of lawyer should litigant be punished. When the default is due to negligence of lawyer, the whole litigant should not be penalized.
Which para?
Para 3, my lord, of that. Not this early on, not this earlier.
They relied upon by you.
Yes, High Court case. 85 supplement. Para 3.
Yes.
That Supreme Court case is like. However, the primary question is whether a default or carelessness or negligence of the lawyer should the litigant be punished. When the default is due to the negligence of the lawyer, whole litigant should not be punished. Therefore, as he was never aware of the fact that the execution proceeding continued on account of dismissing the appeal due to default of the lawyer engaged in the appeal, we are of the firm opinion that appellant, which a villager could not have comprehended that his appeal has been dismissed due to default of the lawyer in so and so. A delay of 6 years in filing the application for bringing the LR, this is respondent on record, has been condoned after setting aside the abatement on the score that appellants in that case were admittedly from the rural area in the country like ours, where so much poverty, ignorance is just. It would not be fair to presume that everyone knows that the death of the respondent legal remedy has been made. This is one case, then other cases are also considered. And the other case also, my lord, I have given this 1995 supplementary SCC that losses will see para 4. Para 4. We have heard the learned counsel on this aspect of matter, and we do not see any reason why explanation was held to be unacceptable. The tribunal proceeded on the technical ground that the advocate, being an agent of the client, knowledge of the former must be attributed to the latter also. And if the former has the negligence, the latter must bear a bond. What was really necessary was to go into the question whether, in fact, factual statement was probable or acceptable. We are therefore the opinion that order refusing the case for default must be set aside. We therefore accept.
No, what is your explanation?
I have said, my lord.
No.
Yes.
My query is, your stance is that you came to know about the pendency only after you you came to know about the dismissal of CRP only after receipt of notice from executing court. But for 4 long years, you did not.
But I have said, my lord, I am communicating with the lawyer. He said that matter is pending.
You communicated
with the engaged counsel. That we can doubt, my
after
lord.
receipt of notice.
No, prior to that, my lord.
Before that also.
Prior to that. That is prior to that. My lord, I am my lord, so backward place, my lord, Hailakandi, your lordship knows, my lord. And these 2 letters, my lord, this advocate in even 25, he said that don't worry, I shall inform you. I was busy. I was out. My lord, he is very much innocent, my lord, person. And he filed this, my lord, this, petition immediately, my lord, after coming to Guwahati, 34/25.
And his submission that you could have seen the status from the online.
My lord, how many of us, my lord, the villagers or the town, but the poor, my lord, the businessman knows, my lord, that these are the things. Your losses knows, my lord, Hailakandi is a very backward, my lord, place. They always depend on the, my lord. Even my many clients, my lord, company people's, my lord, they also rank my junior, my lord, that to know the status. They don't look into the, my lord. That has been done this time.
Heard Mr. G. N. Sahewala, learned senior counsel assisted by Ms. K. Sharma, learned counsel for the petitioner, learned counsel for the applicant. Also heard Mr. P. K. Deka, On seventh, I will pass orders. Learned counsel for respondent. Let this matter be listed for delivery of orders on 7 November.
Leave the press. Milord, in my objection petition, the citation I have discussed, Milord, like to hard copy of this citation I have to place before this copy.
Okay.
Obliged. Item 19. It's IA for condemnation of delay, and prefer in the civil revision.
Heard Mr. What is your name?
K. Mira.
Heard Mr. K. Mira. Learned counsel for the petitioner. This learned counsel for the applicant. This application under section 5 of the Limitation Act 1963 has been filed by the applicant, praying for condonation of delay of 260 days in preferring the connected civil revision petition against order dated 28/10/2024 and 7/1/2025, passed in title suit number 282/2021 by the court of which court?
Court of Civil Judge Junior Division number 4.
By the court of Learned Civil Judge Junior Division number 4, Kachar, Silchar. Stop. Issue notice to the opposite parties. Issue notice to the respondents. The applicant shall take steps for issuance of notice upon the respondent by speed post as well as by usual mode within 7 days from the date of this order, returnable on returnable on 28th of November.
20. May it please, your lordship. This IA is for condemnation of delay, your lordship, of 641 days. In a similar matter, your lordship passed an order, your lordship. I allow that, like, please the order, your lordship. My lord, the other day there was another similar case. My lord had issued notice. I'm placing the order, your lordship.
But
This is a legal education. Actually, my lord, if I may point out, there are 3-4 cases. So all of them may be listed together, my lord. Because the same plot of land, same issue. That will make the thing very convenient. Instead of separately hearing every case. Today 2 has come, previously there were 2, I think. Your lordship, you have passed in a single matter, your lordship. The order is in place before your lordship.
okay, this you
judicial
are praying for an interim relief.
Yes, your lordship. It's for your lordship's order, similar order, your lordship.
Mr. Bhattacharya, you are appearing for respondent number
Respondents 2 and 3.
20.
My lord, I can point out one more thing. In all the judgments, substantial amount of money has been paid by the state. So that way we are concerned. Very high huge amounts has been already paid. And this is legal education in the name of education method. And I'm not saying that the amount should be reduced drastically, but it should be reasonable, that is all. I'm not taking sides.
Heard, Mr. You have to take some side. You
But I
cannot
am the
do,
state, my lord.
you have to take
Yeah,
the
we
side
think
of
about
the state.
everybody. Including the court.
Heard, Mr. A. Das, Learned counsel for the applicant. Learned counsel for the applicant. Also heard Mr. K. Bhattacharya, Learned counsel for respondent number
2 and 3. 2 and 3.
I to the respondent number
2 and 3, lord.
this 2 and 3. 2 and 3. This interlocutory application has been filed under proviso to section 74 of the right to fair compensation and transparency in land acquisition, rehabilitation and resettlement act 2013, read with section 5 of the limitation act, for condoning the delay of 641 days in filing the connected land acquisition appeal. Let the notices be issued to the respondents. Since Mr. K. Bhattacharya has already appeared for respondent number 2 and 3, no formal notice need to be issued to the said respondent. As regards respondent number 1, the petitioner, the applicant shall take steps for issuance of notice on the said respondent by registered post with AD within 7 days from the date of this order, returnable on 28/11/2025. The learned counsel for the applicant has submitted that in the meanwhile, the decree holder, who is the beneficiary of the award, namely respondent number 1, has already filed execution case number
1 of 2025.
has already filed an execution case, namely execution case number 1 of 2025, which is pending before the Court of Learned,
Additional District Judge.
Additional District Judge Kamrup, Amingao. He further submits that unless the execution of decree is stayed, the applicant would be highly prejudiced as in case of execution of the decree, the accounts of the applicant university may be frozen, which may jeopardize the future of many students undergoing various courses therein. Stop. I have considered the submissions made by learned counsel for both sides. Though the grant of stay of execution while considering an application for condonation of delay in preferring the connected appeal is rare. However, as the apprehension shown by the applicant university indicates that without deciding the connected land acquisition appeal filed by the applicant, the execution of the decree obtained by the beneficiary may jeopardize the future of a number of students pursuing various courses in the said university. Hence, this court is inclined to stay the execution of money execution case number
1 of 2000.
1 of 2005 till next returnable date. List the matter again on 28/11/2025.
21. Same year out.
21 days.
I'm appearing that also, same order, man. Same order.
21 same order.
Only the petitioner, the respondent's name is different, private respondent. Money execution,
Name order.
Money execution case number
Money execution case number
13 of 2025.
13 of 2025.
There is delay of
And
509 days.
delay of 509 days. Baki একে থাকে
2811.
2811.
Much obliged, Your Honor.
Item 24.
Yes.
There was a small error. Actually, because of that error, it was held up. We had not, our clerk had not filed it. So finally, we put it filed and tagged. The additional affidavit to the interlocutory application of 1949.
What is 1949?
That is an interlocutory application for adducing, for bringing in the new facts and reports.
Order 41
Under-
rule 27.
Yes. 41, 7 and section 38 of the Evidence Act, that is BSA. And section 17 of the
Yes,
Litigation
no.
Act.
Yes, more. BSc, Bharatiya Sakshi Adhiniam. Act. Bharatiya Sakshi Adhiniam. Evidence Act. উপরতে আছে কত কিন্তু উপরতে আছে আপনি লারি থই দিন Yes.
Thereafter, they have filed a, so the name of the, I find
BSA which section?
38.
What is that?
That is for judgments or orders obtained by fraud. Fraud or collusion in obtaining judgment or inconsistency of court may be proved.
Okay.
Thereafter, Your Honor may kindly produce page number 4 of the IA 1949.
1949, page number?
That is part of the post title.
Yes.
Rumi Bonik is the main defendant. And she is the daughter of the original plaintiff, Gita De. It's written as Gita Bonikpa, but we have our documents to prove that she is Gita De actually. And thereafter, they have filed an affidavit in opposition, but she has not defended herself at all in this IA. So all the allegations that we have made against her is deemed to be accepted by the court as proven.
No.
For
You have to tell me the gist
the
of
gist, the
gist.
background,
in very briefly.
very brief. So a suit, title suit TS 30 was filed in 1998
By whom?
by the mother of this Rumi Bonikpa. Her name is actually should have been Gita De, but she represented impersonating as Gita Bonikpa. And that is given in page number
Who, the
1.
plaintiff?
Plaintiff, the original plaintiff.
Plaintiff was Gita,
She should be Gita De.
but as Gita Bonika,
Represented her, impersonated herself as Gita Bonikpa.
against whom the title suit was
That-
filed.
The defendant number 1 was Nibha Bonikpa. And the defendant number 2 was her husband, and defendant number 3 and 4 were two minor sons of Niva Bonikko. Niva Bonikko is Niva Bonikko, the actual owner of the land.
What relief was sought for him?
The relief sought was title, eviction, and injunction. And the suit is valued at rupees 2,000 only. And that was in 1998. Thereafter, they have said in their paragraph 2. So this is the background. And
Thereafter, what happened to the suit?
thereafter, this
Suit was decreed or dismissed?
after there is a small twist here. The performer defendant, Jitendra Narayan Bonikko, of whom Gita De claims to be a wife, actually is not her husband. He is her employer. And he had another lady as his wife called Aruna Bala Roy. That was the name of his wife, with whom he has obtained a divorce. And Jitendra Narayan Bonikko, on the power of forging certain signatures and things, they had moved this case, let it run for this long. After he passed away, after Jitendra Narayan Bonikko passed away, they adduced witnesses, they brought in several amendments, filed a lot of documents and obtained the decree.
Okay, then you filed an appeal.
Then we filed an appeal.
Appeal was dismissed.
Then we were here the case was going on. And then when it was CAV, the matter came to me. I looked at the documents and I know that matter is not maintainable under section 154 of the Land Revenue Regulations. And thereafter, we have gone through all the documents. We're trying to bring that on record. And we have filed an additional affidavit recently. The confusion on which the additional affidavit arise. There we have brought in the two
Additional affidavit for adducing additional evidence.
Actually, we didn't bring in additional evidence here. We just filed the copy of the plinth of Title Suit 30, and then there was an amendment in January 2002 that also we got. Now that has become relevant because this defendant number one is not defending himself. So we have prayed for an amendment of the main appeal member, the second appeal member. So this is our limited prayer actually, but I have to take your lordship through the materials, through the evidence.
No, now in this interlocutory application under Order 41 Rule 27, what prayer you have? What is?
That there also we have prayed. We were.
No, in this interlocutory application, what is the prayer?
So we have prayed here for bringing in the records in the suit, to be allowed to bring in the records as evidence.
What records?
The annexers that we have filed. The annexer 1 to annexer 22. There's much more that has to be said because it's all within the IA. We have made several allegations which they have not replied to, and therefore we are trying to invoke the chapter 3 where court has to take notice. Chapter 3, facts judicially noticeable need not be proved, facts of which court shall take judicial notice, and facts admitted need not be proved. And these we are bringing in our additional affidavit, we have prayed for that. May I take?
Now in the connected RSA, what substantial question of law was formulated?
In the connected RSA, which was not filed by us, they had got into a very valid point though.
In the RSA, what is your status?
We want to amend the RSA.
No, what is your status? Are you appellant there? So why are you saying it is not filed by you?
It was filed by the previous council.
No, no, I'm not about council.
Yes, so there is a.
The
uh,
parties
difference
remain
of-
same.
The parties are same, but. there is a
What was
difference.
the substantial question of law formally?
They were arguing on the Transfer Property Act. And then they were also making certain claims on,
They means you.
there is a difference. I would kindly pray, the court to take into cognizance the IA, which actually brings in the record of the materials which were hidden earlier. And unfortunately, the councils who had filed the RSA also didn't have access to those. Somehow, they had missed those points. So therefore,
No, no, I want to understand very simply
yes,
that you filed the RSA challenging the concurrent finding of two courts, whereby your which
concurrent findings of the two courts where
first appellate court and say and the trial court.
and the trial. They
And therefore I am asking what
suppression of fact. It should be suppression of fact.
what substantial question of law was formulated and
Substantial-
whether to decide that substantial question of law. Additional evidence is necessary at the second appellate stage. Whether can we go into the evidence at this stage?
We can.
So what was the RSA?
I am.
What is the substantial
They-
question?
When it is page number 18, I have to say.
They means who?
They means the councils, because these are laymen. They are not judicial people. They have brought all their papers. Somebody has to guide them judicially, how it's going to be, what it's going to be, which is the correct forum. So since we know that there are there's some kind of collision, there's lots of things which are irregular. So therefore, although the page number 18 has certain substantial questions of law, particularly on the
No, what was formulated?
Transfer of Property Act, section 122. And the validity of the sale deeds should be list pendency actually. So 1, 2, 1, 4 days, some two sale deeds were done. And now, most importantly, the defendant number 1 is no longer defending.
No, just a minute.
And we have also
By
filed-
which no substantial question of law has been formulated.
How far they have gone, but we have not seen anything else. Because it was in the admission stage. We have seen only the page number 18. And here our prayer is very limited, but I pray your lordship to kindly
Okay,
hear
okay.
this.
So in this case, substantial question of law is yet to be formulated.
In fact, my lord, my learned friend, Mr. Bhaskar Datta, he appeared for the appellant. Your lordship at this stage heard the entire matter and your lordship decided to finally dispose of the second appeal, either by framing substantial question of law or
By dismissing the appeal.
Yes.
in the two. At
Our-
that
our-
stage, this
Your
I has
lordship-
been,
Lordship reserved the judgment. It was made CAV. In between, it appears there is a change of counsel and filing of an application under Order 14 Rule 27 to take in additional evidence. This is the position. I'll make my submissions, Lordship.
Now, I pray for your lordship to, if I can take you through the,
no, before that, I have some basic questions. The the regular second appeal is yet to be admitted.
yes,
Can you file an application under order 41 rule 27 at this stage before admission of?
yes, we are allowed to file because the
No. Help me to understand. Suppose your appeal is not admitted, then where does this IA would stand? In case the appeal is dismissed, In case the court finds that there is no substantial question of law involved, first you have to get the. You may answer.
So, Lordship knows that if there is a fraud, any forum, anywhere, it has to be addressed within the justice delivery system. Since the matter has come up here, the courts here, which is obviously the higher court, the highest court in this region, has to address this issue. So that is a settled position.
What is the procedure to be adopted under such a?
I have found out that our procedures, the SOPs that we need to have in place, our High Court, we do not have it in place.
No, you suggest with this.
The
In
procedure,
this case,
yes,
you filed a second appeal, which is yet to be admitted.
we are just seeking to amend the second appeal.
The
Because
memo of appeal.
the appeal memo. We are just seeking to amend the appeal memo with all the evidence that we have collected now, because a grave injustice has been done by even
But for amending,
question of maintainability of this suit in a civil court. A civil court doesn't
but
have
you have filed
jurisdiction.
an application under order 41 rule 27,
Fine,
not for amending the memo of appeal.
that is true. We have filed on this because this presides over the amendment. Later on, when they are not also willing to defend on the order 41, that is when we are seeking to amend in our additional affidavit, which is very well within the review of the practices going on. So very small and relevant point here is, if a matter has gone on for so long, which is actually barred within the jurisdiction of the court system, then I bring your lordship to section 52 of chapter 3, which says, facts of which court shall take judicial notice. The court shall take judicial notice of the following facts, namely, all laws in force in the territory of India, including laws having extraterritorial operation. The Assam Land Regulation, section 154, bars jurisdiction of a land which is under settlement. It says,
Do you want to amend your memo of appeal? Is that the
yes.
basic requirement
Basic requirement
at this stage?
for solving the entire issue is to amend the appeal.
Then you have to file appropriate application.
Yet one other one.
No, I
That may
don't
be
know.
decided later.
I don't know. You have now filed an application for adducing additional evidence under.
Like I said, since they have not come up on any defense with that, that is why we filed an additional affidavit on this. And we have prayed in the additional affidavit. If I may take your lordship through the additional affidavit, I'll just take a few minutes. In the additional affidavit, page number 112. How are we going to resolve the maintainability issues at this stage? There's no SOP about that in our.
No, but you have to take that plea in your memo of appeal. If there is any question of law is involved, you have to take that plea in your memo of appeal. You have to precisely state that this question, because we are at the second appellate stage.
Second appellate stage, they have
Even if you allege fraud, that has to be taken in your memo of appeal.
they like the fraud was discovered post filing of the memo of appeal.
Maybe, then you have to pray for amendment of memo of appeal.
That is
Where?
in the additional affidavit. Page number
Additional affidavit prayer may not be made.
of the
Um,
interlocutory application. So we'll have to file one more interlocutory application then. We have
Where is the additional affidavit? Page number?
Page 110.
Where is the prayer?
The prayer is at the end. Paragraph number 7. That the appellant number 1 begs to state that her brother was named as performer defendant in the suit and did not participate in the case at all. He was also residing in different places, including in the appellant's house. The gift deed and the evidence on affidavit's signature does not match his signature, name or signature. He passed away before any cross-examination took place. Before this, the other paragraphs also are important. Hence, the entire title suit 1998 and title appeal 17 of 2016 was managed with the fake documents with the without the presence of the appellant number 1's brother. And that is one prayer. Therefore, a detailed amendment of the appeal memo is necessary. Then I bring your lordship to the paragraph number 4, page number 112. The original case instituted by the plaintiff Gita Day registered as title.
No, okay. Small basics. This is the statement. You have not made any prayer. You have reasoned that amendment is necessary.
And we have prayed in the second, paragraph number 6 as well. In an additional affidavit, we usually do not include the prayer portion as a prayer portion. So therefore, we have included it within the pleadings.
So your basic prayer is to amend the appeal, memo of appeal on the ground that the decree in the trial court as well as first appellate court was obtained by using fake documents.
Because does not even, they know it's a Kotyondar land. Since they know that it is a Kotyondar land, it shouldn't have gone on as per the land records. Hence, the notice of the court is very important. Hence, section 52 of chapter 3 BSA Evidence Act is very important. They should have not taken cognizance of this case at all because civil court is barred. Except when otherwise expressly provided in the regulation or in rules issued under this regulation, no civil court shall exercise jurisdiction in any of the following. That is A, questions as to the validity or effect of any settlement or as to whether the conditions of any settlement are still in force. So, Kotyondar land, there are periodic pattadars. When there are periodic pattadars and it is expressly admitted in their plain that it is a Kotyon land. Hence, the civil court jurisdiction itself is barred. This matter is not maintainable here. They should have approached the circle officer and the DC office, that is the Deputy Commissioner's office, for any land dispute.
So you want to challenge the appellate court's judgment on this ground?
On these grounds. There are several other grounds we have prepared. That is why because it is a developing case, Lordship must take into cognizance that some of the matters we have come to know only now. For example, there were documents within the files that the the defendants, original defendants had submitted to their counsel, but the counsel didn't submit it in the court. He didn't make it part of the case. They have no way to know what's going on. They're not legally trained. They might know their simple right to the land and they're in possession. It's an admitted position of the defendants, that the appellants are in possession of the place. When they know that it is a Kotyon land, when they know the possession is with the original owners, then they have come and filed the case in a civil court which has no jurisdiction whatsoever. That is why this section 52 is so very important. And then obviously section 51 and 53.
No, it was a contested case before the trial court.
The counsel is in coalition of some kind and he didn't take due diligence and precaution to file the documents before the court couldn't take appropriate decisions, perhaps. Although, or there is a big chance of error in the court's orders because Khotian word is written everywhere. When the Khotian word is written everywhere, how can the court take cognizance? The court shouldn't have take cognizance of this matter itself. There's a big error on the part of the court.
Okay, now what is your prayer in this IA?
Very limited prayer because in additional affidavits, we usually do not write a prayer portion. So we included everything within the pleadings. We just want to begin with amend the second amendment.
Under what provision?
Under the provisions as I have prayed for.
Under order 41.
If Lordship will hear me on the provisions of amendment separately, then you may fix a date and I'll bring one. I have it already. Today I came prepared more on the grounds of maintainability and the fraud that has been committed. And
No, we cannot go into those questions now. Yes, Mr. Majumdar.
Yes, if my learned friend is completed, then I'll stop.
She had prayed for some time to come.
If it's asking merely for time to come prepared, then it's another issue. But otherwise, on merit of the application she has filed, I can make my submissions.
I'm willing to hear him today. So I come prepared on the amendment issue alone for the next time, because it is very important for the court to devise a method for the people to get justice. And the court has absolute liberty to devise.
No, you have to assist the court. If you are alleging that fraud has been committed upon court, how the court should proceed in a regular second appeal, where there are many restrictions as to section 100 is clear.
Those restrictions are overcome by these other sections.
This order 41 rule 27.
Read with section 38 of BSA as well as
Either you file an appropriate IA.
file an
This-
appropriate IA. Fine. Because it's all
No,
developing.
this is, I'm not directing you.
I understand. It is because we're trying to devise a method of going through the whole process properly. Will file an appropriate IA. Some of the things also came up after I received their reply. So I'll file an appropriate IA.
Yes, Mr. Majumdar.
First of
Her
all,
prayer is that she will be filing an appropriate IA.
my submission will be, we are in the High Court, the highest court of the state. There, when we make an application, make a submission, there should be some seriousness into it. Application has been filed under Order 41 Rule 27, which only enables the Honorable Court to permit or to grant leave to adduce additional evidence. And Lordship will consider that application and today's all other prayer in terms of the application that has been filed. If a case has been made out for adduction of additional evidence, very well, your Lordship will grant. And if no case is made out, then Lordship, after hearing the counsel for both the sides, when the Lordship, when this Honorable Court fixes the case for judgment, in between, if there is a change of counsel and there is no law which enables this Honorable Court to hear the matter again. Otherwise, in every case, after the hearing is over, if your Lordship passes the order after 2 days, in between, on the first day, second day, another counsel will come and file an application, say that I want to make certain new application and with a new prayer, and Lordship will grant me to amend the prayer, and your Lordship will grant me to file some documents. Will tell this will be an endless process, my lord. This is not permissible under the law. Lordship has heard the matter. Second, if not 1 day, my lord, your Lordship heard this matter, I think, on 2-3 occasions. And after the hearing was completed, your Lordship has fixed the matter for judgment. Supreme Court says after the matter is fixed for judgment, because appeal is a continuation of a suit. under order 20 rule 1, my lord, your lordship has time to file, pass the judgment within 30 days. Or your lordship may pass even thereafter if your lordship fixes the date. But in between, normally there is no scope for filing an application for adducing additional evidence. That cannot be entertained and that should not be entertained in my humble submission. Now coming to the application, lordship will kindly see, this is absolutely nothing but an abuse of the process of the law. I will show you, lordship. And the lordship will kindly take up their application IA, there is 1949.
Yes.
If your lordship remembers, this matter was heard on 2-3 occasions. At last, after completion of hearing, the lordship has fixed the matter for judgment. On merit also, I'll make my submissions after that, after I complete my submissions on this IA. I'll show my lord how this is an absolutely an abuse of the process of the court, my lord.
Yes.
Lordship may kindly take up the IA, my lord.
Yes.
The IA, I'll show my lord, IA has to file basically on the ground that there is a fraud by which the decree has been obtained, number one. And number two, there are certain documents which they have discovered subsequently in order to bring the application within the purview of Order 41, Rule 27, which says that if you had a document, but you were prevented from producing it before the trial court, you can be allowed. Or if you did not have the knowledge about some documents, subsequently you discover, on that ground also you can come to the High Court or any other appellate court for adducing additional evidence. That is permissible. Now here is a case where they have taken a plea that the decree has been obtained by fraud and the documents and other materials based on which they are saying that the decree has been obtained by fraud were discovered subsequently, and that too after this second appeal was filed.
Yes.
Now, lordship may kindly see why I am saying so. Lordship may kindly take up their IAML. Lordship may kindly turn to page 9 first.
Yes.
Page 9, paragraph 2, they say whether now they are asking some court to frame, it says synopsis and substantial question of law. I do not know how a synopsis and substantial question are interchangeable. Number Roman 2, my lord, whether the decree in title number so and so and so and so is obtained by fraud and collusion of the defendants and the counsel of the petition, Abdus Samad. Abdus Samad did not file the various land documents of his client, that is thereby concealing them from the defense side and failed and neglected to protect the rights of the defendant appellant who were in possession of their ancestral land and had all rights, title, interest, and claim over it while he let the case drag over 18 years in the municipal court at so-and-so and at about 9 years in the appellate court in Bongaigaon district. When my lord, the clients or litigants approaching the court, they have a right to say that, yes, the matter has been dragged. But if they say that this matter has been dragged because the court did not take up, it's casting aspersion on the court. Anyway, my lord, second paragraph, my lord. Defendant counsel Abdus Salam had all the land documents in his files and in his possession, but he did not file them in both the courts, misleading the clients at all the while. So the counsel has misled. So yes, counsel has misled the client. This is the allegation against the counsel, their own counsel. Is the lordship rising, my lord?
Yes, we have to raise. Reference is there.
Right.
Wo-
Let me continue tomorrow. Tomorrow court is open.
I don't have any objection.
I'll make my submission because in my humble submission, this application has to be thrown out simply on the ground that this is an abuse of the process of the court.
I have
One
serious
sentence,
objections on that.
one sentence I am showing, they have Lordship may kindly turn to page 26
No, we'll take it up tomorrow.
tomorrow, yes.
I have serious objections to his, when a fraud is committed and he has no defense, he cannot even come up with the pleas that he is. I have to, with full respect to.
I will show my lord, this
learned
application
counsel.
is absolutely an abuse of the process of the court. Tomorrow I'll complete.
No. Tomorrow, but you have to satisfy the court that merely because fraud has been alleged at different stages of litigation, how the allegation of fraud is to be dealt with. We are in the second appeal,
The second- and
where where your appeal is yet to be admitted. So how you will place the,
Therefore,
what is to
I
be
have
done, you have to assess.
may be allowed at least 2 weeks' time to file the second I.
Well, this honorable court is not here to grant time to file IA. Your lordship cannot grant
It
time.
has to-
You, there is no restriction on,
There is no restriction.
you can file tomorrow also.
I will not be able to file because I have 3-4 fixed matters in various courts. So 2 weeks' time will be necessary to, because we have scheduled ourselves in a manner.
No, otherwise this
Or at least,
My lord, she has completed her part.
I
Let
have
me
not-
give my reply. Tomorrow I'll give my reply.
I have not completed my part. I sought time, then because he wanted to make these submissions, he's made. We have agreed upon that we need to amend the second appeal, and hence I need time to file an appropriate application. No more injustice should be conducted in this matter, where maintainability is in question.
fourth or 11th. Mr. Majumdar. Either on 4th or 11th.
So today we have fixed matters.
Let it be on
Anything-
fourth one. Fourth.
Fourth, I cannot, again, lots of fixed matters, and besides we'll file, so anytime after 11, a date may be fixed. I'm also willing to have a fixed date.
Thirteenth.
14? 14?
Yeah.
14 could be.
14 is a.
Sunday.
14 is Sunday.
14 is a motion day.
Motion day.
15?
15th is
November.
uh,
Okay, sorry.
holiday. 17?
Let it be 20th, my lord, is a hearing day, it will be better. 20th, 20.
Heard. Miss A. Saikia. Learned counsel for the applicant. Also heard Mr. D. Majumdar, learned senior counsel assisted by Mr. B. J. Mukherjee, learned counsel for the respondent. Though the counsels of both the respective parties have made submissions on the interlocutory application number 1949/2025. Due to paucity of time, full hearing could not be conducted. Let this matter be listed again on 20th of November.
20th. Much better.